on Domino's checkout.
your smile. While the sunshine brings the light, fill me out with a flame. I will let you in this game. Take me out when I'm down. 'Cause with you I'm safe and sound. 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 I'm safe and
Soft waves calling in the night, neon skies and silver light, footsteps faded in the sand, rhythm moving through the land, ocean breathing slow and low, feel the midnight currents flow, every heartbeat starts to move, dancing in the seaside groove. So far away, we don't need the words to say, just the sound of distant tides and the rhythm deep inside. Wind is whispering your name, nothing here will feel the same. Every wave becomes the truth when we move in seaside groove, seaside groove. Feel it rise, ocean rhythm in our eyes, move your soul into the blue. Let the night flow into you. Seaside begin to glow. Time is fading with the tide. Every dream is amplified. Close your eyes and feel the air. Ocean whispers everywhere. Hearts are floating through the night. Side groove, feel the bass. Moonlight dancing on your face. Every shadow starts to move. Lost inside the seaside groove. Seaside groove, wild and free. Echoes drifting through the sea. Turn the silence into sound. Let the rhythm spin around. Morning slowly paints the sky. Waves are singing their goodbye, but the rhythm still remains, flowing softly through our veins. Seaside groove fading slow, like the tide that comes and goes. Every heartbeat still a bruise, living in the seaside groove. Rhythm moving everywhere. Gentle echoes from the street.
Good morning to the honorable judges, respected faculty members, and everyone present here today. It is a privilege to welcome you all to today's proceedings. We often think of law as something that is written and settled, but in reality, it takes its true shape only when it is questioned, interpreted, and applied. It is in spaces like these that the Constitution moves beyond text and begins to function as a living document. This event is organized by the Deccan Education Society, founded in 1884 by visionary leaders such as Sri Lokmanya Bal Gangadhar Tilak, Sri Gopal Ganesh Agarkar, Sri Vishnu Shastri Chipunkar, and Sri Vamanrao Apte. Built on the belief that the education is the lifeline of a progressive nation, DES has for a century remained committed to nurturing responsible citizens and shaping the intellectual landscape of India. Carrying forward this legacy, DSS Sri Navalmal Firodia Law College, Pune, established in 2004, stands as a premier institution for legal education. The college is committed to academic excellence through innovative technique and a well-rounded approach. With a strong focus on research, advocacy, and practical exposure through moot courts, legal aid, internships, and various co-curricular activities, it continues to shape competent and socially responsible legal professions. At the heart of this practical exposure is the Moot Court Society of our college, which represents the college at state, national, and international competition, bringing laurels to the institution. This initiative is one such effort. I now invite you to take a look at their journey and achievements.
At BS Sri Firodia Law College, the pursuit of excellence in advocacy begins within the institution itself. Every year, during the months of September and October, the college conducts its intra-annualized moot court competition, a rigorous selection process involving comprehensive memorial drafting and oral advocacy rounds. From this process, the top 50 students are selected, students who go on to represent the institution at various prestigious platforms, including moot court competitions, mediation, client counseling, trial advocacy, area competitions, and judgment writing contests. Dynamic year 2025-2026 has been marked by enthusiastic participation and exceptional accomplishments with consistent performance. We are proud to present the achievements of the Moot Court Society for the year 2025-2026 till 8 good 2026. These accomplishments reflect not only individual merit but also the institutional commitment to excellence in legal advocacy. We take immense pride in the fact that many of these achievers are present here today, contributing as speakers, researchers, report writing panel, and volunteers for VidhiVedh. These achievements have been possible only under the constant guidance, encouragement, and visionary leadership of our esteemed patrons at the Sri Firodia Law College. We extend our sincere gratitude for your unwavering support and continuous encouragement, which inspires students to strive for excellence and achieve such remarkable heights. The journey continues, and we look forward to many more laurels in the year ahead.
What you just witnessed is not just a record of achievements, it is a reflection of the standard of advocacy that defines this institution. And it is the very standard that brings us to VidhiVedh. The term itself is telling. Vidhi meaning law and Ved meaning a deeper insight or examination. Together, it reflects the essence of this event, not just to apply the law, but to question it, analyze it, and understand it in depth. VidhiVedh is not simply a mock hearing. It is an attempt to recreate a constitutional courtroom in its true sense, where arguments are not just presented but tested, questioned, and refined. It allows us to engage with constitutional questions here in this very space before they unfold in reality. With a 9 judge panel, clearly defined courtroom roles, and a structure that mirrors real proceedings, the event captures both the seriousness and the complexity of constitutional education. What makes it particularly significant is that it goes beyond the hearing itself. Every argument is carefully documented, and a dedicated report writing panel analyzes the proceeding, ensuring that the discussion does not end here but continues through reflection and understanding. At the heart of today's proceedings lies the Sabrimala case, Indian Young Lawyers Association versus State of Kerala, a matter that raises fundamental questions about the balance between faith and constitutional rights. To better understand its context and evolution, let us now take a brief look at its background.
एक देश था जिसका नाम था इंडिया। इस देश में अलग अलग लोग थे, अलग धर्म, अलग सोच और अलग जिंदगी के, पर इन्हीं सबको साथ रखता था द कॉन्स्टिट्यूशन ऑफ इंडिया। इसमें लिखा गया था कि सभी लोग बराबर हैं, सभी को गरिमा से जीने का हक है तथा अपना अपना धर्म मानने का भी हक है। एक मंदिर था जहाँ कुछ उम्र की लड़कियों को जाना मना किया गया था। कुछ लोग कहते थे कि यह परंपरा है और यही सही है, तो कुछ लोग कहते थे कि यह संविधान के खिलाफ है। एक तरफ धर्म तो दूसरी तरफ कॉन्स्टिट्यूशन, कौन सही था? तब जाके ये सवाल पहुंचा देश की सबसे बड़ी अदालत सुप्रीम कोर्ट ऑफ इंडिया में, और जजेस ने तय किया कि अब हमें ही तय करना पड़ेगा कि क्या सही है और क्या गलत। अब ये कहानी सिर्फ मंदिर तक सीमित नहीं रही, ये बदल गई है कुछ बहुत बड़े सवालों से जिसका जवाब पूरा देश ढूंढ रहा है। पहला सवाल, हर भारतीय नागरिक को अपना धर्म मानने का हक है, पर क्या इस हक में वह कुछ भी कर सकता है या फिर इस अधिकार की भी कुछ सीमाएं हैं? दूसरा सवाल, अगर एक तरफ एक व्यक्ति है और दूसरी तरफ एक धार्मिक समुदाय, तो महत्व किसे ज़्यादा दिया जाएगा, उस व्यक्ति को या उस धार्मिक समुदाय को? तीसरा सवाल, क्या धार्मिक समुदाय के अधिकार फ्री होते हैं या उन्हें भी कॉन्स्टिट्यूशन के रूल्स फॉलो करने पड़ते हैं, जैसे समानता, सुरक्षा और न्याय? चौथा सवाल, मोरालिटी का मतलब क्या है? क्या हमें फॉलो करनी चाहिए पुरानी सोच या कॉन्स्टिट्यूशन वैल्यूज़? पांचवा सवाल, क्या कोर्ट डिसाइड कर सकता है कि धर्म में क्या सही है और क्या गलत? छठा सवाल, जब कॉन्स्टिट्यूशन कहता है कि सेक्शंस ऑफ हिंदूज, तो इसका मतलब क्या होगा? क्या सभी को अलग अलग माना जाएगा या फिर एक ही कैटेगरी में? और सबसे इम्पॉर्टेंट सवाल, क्या कोई जो उस धर्म का है ही नहीं वो भी इस प्रैक्टिस को चैलेंज कर सकता है या नहीं? इन सारे सवालों के जवाब अभी तक क्लियर नहीं है, इसलिए बैठने वाली है एक 9 जज बेंच, और इसी अवसर को हम 5 दिन पहले रिक्रिएट कर रहे हैं। और आज आप इसी एक ऐतिहासिक कहानी का हिस्सा बन चुके हैं। बिफोर द बेंच assembles and before the nation hears it, VidhiVedh.
With that context, we now move on to the proceedings of the day. It is my honor to introduce the esteemed bench that will be presiding over today's hearing. I now request Dr. Janvi Ghodke ma'am to felicitate the honorable judges. We are very privileged to have with us Honorable Shri Sunil G. Ved Pathak sir, who retired as a Principal District Judge Nanded in January 2026 after a distinguished judicial career that began in 1995. Having served across various courts in Maharashtra, including handling commercial and POCSO matters in Pune, he brings with him vast judicial experience. Honorable Dr. Sanjay Jain sir, Professor at NLSIU Bangalore and former Principal of ILS Law College Pune, with over 27 years of teaching experience, a distinguished scholar in constitutional law and a member of the Supreme Court Committee on Accessibility, he is widely recognized for his contribution to disability rights jurisprudence. मॅम त्यांना खालीच बसायला सांगायचं होतं जजेसना. Honorable Miss Vinaya Anand Raichur, ma'am, Deputy Draftsman cum Deputy Secretary in Law and Judiciary Department, Government of Maharashtra, Mantralaya, Mumbai, bringing valuable expertise in legislative drafting and governance. Honorable Advocate Ashutosh Srivastav, member of the Supreme Court Bar Association, with over 2 decades of experience in criminal litigation, widely recognized for handling high-profile matters involving agencies such as CBI, ED, and SFIO, an internationally acclaimed practitioner, he was conferred with the Mahatma Gandhi Samman at the House of Lords, London, for his contributions to the legal profession. Honorable Advocate Om Prakash Kashid, a legal practitioner with over 30 years of experience, appearing before the Honorable Bombay High Court Nagpur bench with a master's degree in constitutional law and a diverse academic background in English and economics, he brings rich legal and scholarly expertise. Honorable Advocate Bhushan Tapasvi, a practicing lawyer with over 23 years of experience across labor, industrial, and civil courts, known for his expertise in labor law matters and trial practice. He has represented numerous companies and institutions in complex disputes. Honorable Advocate Abhijit Desai, solicitor and founder of Desai Legal, with over 2 decades of practice before the Honorable Bombay High Court and the Supreme Court of India, with extensive experience across constitutional, arbitration, and commercial matters, he is widely recognized for his contribution to high-stakes litigation. Honorable Dr. Vikramaditya Rathod, sir, Assistant Professor of Law at ILS Law College, Pune, and a scholar specializing in constitutional and administrative law, with a PhD in law and notable contributions to research and legal education. He is widely recognized for his work in constitutional governance. Honorable Advocate Rajesh Vijay Rathore, a seasoned criminal lawyer practitioner and special public prosecutor who has handled several sensitive cases across courts in Maharashtra with extensive experience since 2007. He is also actively involved in legal training, lectures, and guiding young advocates. We are truly honored to have such a distinguished panel of judges with us today. Before we begin, I request everyone to present here to kindly maintain silence and decorum throughout the proceedings and ensure that your mobile phones are kept on silent mode. I would also like to inform the audience that you may address your questions to the honorable judges through chits You may write your questions on the notepads provided to you, and our volunteers will collect it during the course of the proceedings and present them to the judges on your behalf. Once again, I extend a very warm welcome to everyone present here. With this, we now commence the proceedings of VidhiVedh. I invite the learned counsels of the petitioner to present their arguments before the honorable bench. Thank you.
May it please your lordships. My lords, the issue before this honorable court today is quite significant, taking into consideration the diverse aspect that the Indian society brings. My lords, we all are aware, when we speak of India, we not only speak of Indian society with context of the plurality which it has. Now, lordships are quite aware, since time immemorial, the concept of plurality has always stayed in the Indian subcontinent. And my lords, this plurality, by and large, has been that of beliefs, sections, has been that of religions which we have. And that's what is the beauty, according to me, of this country. My lords, when Constitution of India came into force, it made sure that this particular diversity is accommodated within its provisions. That is, the fundamental rights recognize not only the diverse culture of the society, it protects and promotes the same. My lords, the same is the principle behind Article 25 and 26. Therefore, my lords, the point which is before this honorable court today is significant in a sense that now the threads of this diversity are being stitched together in a common cloth known as the Indian society. My lords, currently there are apparently certain creases on the cloths. Now, your lordships are called upon to iron out those creases without damaging the fabric of the cloth. That is to say, to read a balance between the religious rights and constitutional rationale. My lords, before I proceed to the merits of my case, I'll broadly put to your lordships what the case is all about, or what the reference has been all about. My lords, a case came to be filed before this honorable court challenging the exclusionary practice in Sabrimala temple. Young India Association versus the state of Kerala, commonly referred to as Sabrimala case. In that case, your lordships were pleased to deliver the judgment on 28th of September 2018. The broad issues before these honorable courts were: 1. Whether Ayyappans constitute a religious denomination. Second issue, my lord, was whether the practice of excluding women between age of 10 to 50 constitutes essential religious practice. Your lordships, with a majority of 4:1, held that 1. Ayyappans do not constitute a religious denomination. Second, your lordships held that exclusion of women is not an essential religious practice. My lords, this judgment of your lordships came to be challenged before a bench presided by the then Chief Justice of India, Justice Gogoi. My lords, Justice Gogoi, my lords,
So my question is, can you challenge a judgment delivered by a 5-judge bench? Whether the word challenge is a proper word.
because it was a review petition was filed in pursuant of the same judgment. While your lordships were dealing with the review petition,
When do you refer a matter for review?
my lords,
When do you refer a matter for review?
when a substantial question arises.
So which substantial question has arisen?
Because according to the petitioners back then, your lordships, while deciding Sabrimala, did not appropriately appreciate the element of essential religious practice or the religious denomination. That was the contentions of the petitioners, the review petitioners, who are the original respondents. My lords, later, on 14th of November 2019, the bench comprising of Chief Justice of India, Justice Gogoi, came to a conclusion that there exists a conflict between your lordship's two judgments. That is, one, a decision in Shirur Math. Second, a decision of your lordships in Dargah Committee Ajmer. In pursuant of the same conflict, my lords, your lordships were pleased to refer 7 questions to a bench of 9. Then, my lords, after passing of that order, the question arose regarding maintainability of such a reference. Then, my lords, on 10th of February 2020, a bench led by the then Chief Justice, Justice Bobde, decided over the issue of maintainability and stated that yes, a review bench can refer questions of law to a larger bench. Then, my lords, the order of your lordships on 10th of February 2020 is a 2-liner order. Then, my lords, your lordships on 11th May 2020 gave justifications of that to that order. In pursuant of the same, my lords, today your lordships are dealing with the 7 questions. My lords, I may please request your lordships to turn to PDF page 416 of my compendium, my lords. I would want to show to your lordships the reference order, the first reference order of Justice Gogoi. Do lordships have my compendium, my lords? Your lordship may come to, the operative part starts from PDF page 420, 420. There are the contentions of the review petitioners, my lords. 420. Para 2, my lords. It starts what this court has before it. My lords, of the compendium. Yes. My lords. My lords, page 6, internal page 6. Consequently, my lords, I'll read the relevant part. Consequently, if and when the issues that have been set out in the learned Chief Justice's judgment arise in future, do lordships have para 2, my lords? May I read? In the para 2, my lords, para 2 at PDF page 420. Because it starts the endeavor of the petitioners. The endeavor of the petitioners, my lords, para 2. Yes. The endeavor of the petitioners is to resuscitate the debate about what is essentially religious, essential to religion, an integral part of religion. They would urge that religion is a means to express one's faith. Now, my lords, is the essential part. In the Indian context, given the plurality of religion, languages, cultures and traditions, what is perceived as faith and essential practices of the religion of a particular deity by sections of religious group may not be so perceived as an integral part of religion by another section of the same religious group for the same deity in a same temple at another location. Both sections of same religious groups have a right to freely profess, practice and propagate their religious beliefs as being integral part of their religion by virtue of Article 25 of the Constitution of India. It matters not that they do not constitute a separate religious denomination. Further, as long as practice associated with the religious belief is not opposed to public order, morality and health, or the other provisions of Part 3 of the Constitution of India, the section of religious group is free to profess, practice, propagate the same as being integral part of their religion. Now, my lords, the important part. The individual right to worship in a temple cannot outweigh the rights of the sections of the religious group to which one may belong to manage its own affairs of religion. It is broadly what has been contended. Now, my lords, these were the contentions of the petitioners, who are the original respondents. Now, your lordship may turn to PDF page 423, wherein your lordships will find the issues that are being formulated, my lords. At internal page 7, there are 7 issues, my lords. Internal page 7. PDF page 423. My lords, these are 7 issues which were formulated by lordships. Then, my lords, I'll come to the crux of the issues. I'll come on the wordings of the same, the construction of the same. Prior to that, my lords, if your lordship please turn to para 7 at operative page 8, PDF page 424. Para 7 highlights the conflict that your lordships have felt arises. Your lordships have para 7, my lords. It starts in this context. My lords, para 7 do your lordships have? In this context, the decision of the 7th bench of this court in Commissioner Hindu Religious Endowment Madras versus so and so, that is Shirur Mutt, holding that what are essential religious practices of a particular religious denomination should be left to be determined by the denomination itself, that's one, my lords, and the subsequent view of the 5 judges bench in Dargah Committee Ajmer versus so and so, carving out a role of the court in this regard to exclude what the courts determine to be secular practices or superstitious beliefs seem to be in apparent conflict, requiring consideration by a larger bench. Now, if your lordships may appreciate, at para 7, your lordships have noted that the conflict between these two judgments stands as far as determination of the religious.
No, counsel, if you carefully read the Dargah case, which you are referring to 5-judge bench, it is merely stating that we should weed out the superstitious aspects of the religion, right? It is not questioning the wisdom of the religions to manage their own affairs. It is merely stating that we should try and weed out the superstitious aspects from the religion. And because freedom of religion in India is not an absolute right, it is subject to a number of limitations. And those limitations are, in fact, this right is hedged with limitations. So how do you say that it is a conflict?
In Dargah Committee Ajmer, in fact, in Shirur Mutt, what your lordships have constantly held, that practices that are purely religious in nature be protected. Practices that are secular or otherwise may need not be. Now, my lords, what your lordships have done in Shirur Mutt is, your lordships have left it to the religious denomination to determine what is a religious practice. Or
absolutely, yes.
Or to draw a distinction between the two. As far as Dargah Committee was concerned, your lordship stated that this honorable court or a reed court per se, the honorable high court, would determine what is a religious practice or would separate religious practices from the superstitious practices, secular practices or otherwise.
So, but that court can definitely do. Because that is what mentioned in the constitution.
It is
that only religious practices are protected. So, they enjoy protection. Secular practices and superstitious practices have to be interpreted by the court, have to be separated from religious practices.
With utmost respect.
According to you, in which window this particular practice is falling?
Yes.
Now, basically, considering the moot question that you are not allowing, the trust is not allowing the ladies in reproductive age to enter the shrine, basically. So, according to in which window, as my learned brother had said, according to in which window this is falling, whether it's falling in the superstitious practice or whether it's falling in the religious practice.
With utmost respect, the issues that is before your lordships today, the 7 issues.
Because unless and until you answer this particular issue, we cannot really proceed ahead with the adjudication of this particular aspect.
As your lordships have held in the Sabrimala judgment, this is not an essential religious practice. Your Lordships did not categorize it as a secular or a practice other than a religious practice. Your Lordship did not went into examining whether it is some kind of a superstitious practice. My lords, it was the contention back then in Sabrimala that it has been continuing since time immemorial, and thus it is a religious practice of the Ayyappans to exclude women. Therefore, your Lordships, while investigating the same, has held that though excluding women may be a religious practice, but it is not an essential religious practice as per the tenets of the Hindu religion. Therefore, your Lordships denied to award protection under 25-26. If your Lordships may appreciate, with utmost respect, my lords, what is before your Lordships today is the interpretation of the 7 questions regardless of Sabrimala. Lords, may please appreciate.
No. It cannot be regardless of Sabrimala. Because we are supposed to review the Sabrimala judgment, right? So how can it be regardless of Sabrimala?
Your Lordships are sitting over a constitution bench to answer the questions which are referred to your Lordship.
But the questions are based on Sabrimala.
My lords, if your Lordships may appreciate, with utmost respect, the questions are based upon the conflict arising out of these 2 judgments that your Lordships are recorded in para 7.
That is not
Because Sabrimala,
right, it is.
my lords, my lords. Now, my lords, your Lordships have the second reference order on 10th of May. My lords, thereby your Lordships, one, have not conflicted, or your Lordships have not taken a divergent view with regards to existing on the conflict. Your Lordships were satisfied of the fact that there arises a conflict. Neither did your Lordships enlarged or narrowed down the scope of the conflict, my lords. That's one. Second, your Lordships were pleased to reframe the issues. Now, if your Lordships may have, I have submitted a table before your Lordships for your Lordships' convenience, wherein I have mentioned both of the issues. The Lordship, it is a single page, my lords. The single page, in the left column states first reference order, on the right it's second reference order. My lords, I am trying to point out before this honorable court that the issues that were rephrased, if read in the language as they are being rephrased, do not accommodate the conflict which arises, which is not being disputed. If your Lordships look at the left column, first reference order. My lords, the first issue regarding the interplay between the freedom of religion under 25 and 26 of the Constitution and other provisions in Part 3, particularly Article 14. If your Lordships look at the second column, it says, what the second reference order, what is the scope and ambit of right to freedom of religion under 25? That's one. Your Lordships have considered interplay in issue number 2. If your Lordships look at second reference order, issue 2, what is the interplay between the rights of persons under 25 of the Constitution of India and rights of religious denomination under Article 26 of the Constitution? Well, for paucity of time, I will cut short my arguments and specifically bring your Lordships to your Lordship may turn to issue number 6, which is at the bottom of the page of the first reference, my lords. Whether the essential, your Lordship has that, whether the essential religious practices of a religious denomination or even a section thereof are afforded constitutional protections under Article 26. Because it is our case that the issue in the first reference order stands, or it accommodates the entire conflict or the heart of the conflict. Whereas, my lords, such an issue is not being rephrased by this honorable court. If your Lordships look at issue number 3 at the second reference order, it says whether the rights of a religious denomination under Article 26 of the Constitution of India are subject to other provisions of Part 3 of the Constitution of India apart from public order, morality and health. My lords, this issue does not accommodate the aspect of essential religious practice. My lords, when it comes to conflict between Shirur Math and Dargah Committee Ajmer, the essential religious practice apart from other aspects of those 2 judgments is the heart of the issue. My lords, therefore, the reason I am pointing this difference is, it is our request that your Lordship may please hear us beyond the scope of the present issue. Your Lordships may not only consider Part 3, but also your Lordships may hear us on essential religious practices, which is going to be one of my submissions.
Shantanu,
yes.
Now that has been referred
My
to
lords.
the 9 judges bench. Now since it has been referred, it is to be relooked in all respect.
My lords.
And while in the process of interpretation,
My
these issues which have been drawn, they shall be they shall be followed in the subject of interpretation. Now, my question to you is as to whether there is occasion for us to relook on the issue as to whether we should go beyond essential religious practice.
Your Lordships may appreciate.
Reason being
Well,
that there are 3 riders which are laid by Honorable Dr. Ambedkar,
Milos.
and he read it that if there should be 3 riders,
Milos.
one is health,
Public
then
order, health,
morality,
morality.
and
Milos.
public order. Now, whether in this context it should be decided, instead we are confining to a particular religious practice,
Milos,
because they are the riders which are the source to understand it and to draw conclusions.
Milos, humbly, to answer the question in one line, Milos, with utmost respect, it is the case of the petitioners that the subclassification or the test of essential religious practice has to be revisited once by Lordships. But I'll come to that while dealing with the merits of issue number 3. Lordships may accommodate me till then. Milos, now I'll be dealing with issues 2 and 3 before this honorable court. If your Lordships look at issue number 2, what is the interplay between the rights of person under Article 25 of the Constitution of India and rights of religious denomination under Article 26 of the Constitution of India? Milos, I'll state your Lordships the current position that your Lordships have delivered in Devaru, Milos. In Venkatramana Devaru, your Lordships have, Milos, it's a 1958 judgment. Well, for the paucity of time, I'll quickly state to your Lordships what did Devaru say. Because Devaru stated that when constructing Article 26 and Article 25 is concerned, Article 26b has to be harmoniously constructed with Article 25(2)b. If your Lordships for a moment have the Constitution of India, Milos. If your Lordships may open 25 and Article 26. Milos, Article 26, may I read? Article 26, well, I'll come to 25. Article 26 deals with subject to public order, morality and health, every religious denomination or any section thereof shall have the right. Now your Lordships have the Constitution of India enunciates this right into 4 categories. A, to establish and maintain institutions for religious and charitable purposes. B, to manage its own affairs in matters of religion. C, to own and acquire movable and immovable property. Consistently of the point that as far as 26 C and D is concerned, that can be regulated by law. But Milos, your Lordships in Shirur Math for the first time said that when it comes to 26B, that cannot be regulated by law. Now if your Lordships look at Article 25(2), well, Article 25 is freedom of conscience and free profession, practice and propagation of religion. Now Lordships may turn to Article 25 subclause 2. Subclause 2 states, nothing in this article shall affect the operation of any existing law or prevent the state from making any law. Below this provision enables the state to make law on subjects mentioned in subclause A and B. Now Milos, subclause A, regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Now Milos, in Devaru, your Lordship said that 26B has to be read harmoniously with 25(2)b. Milos, this establishes a interconnectivity between the two. Milos, with utmost respect, this is our case. That as far as their interconnectivity is concerned, these two provisions of law are interconnected to a particular limited extent. That is to say, that when an individual gains a right under Article 25 to practice, profess, propagate his religion, it then enables him to get a right as a religious denomination under Article 26 for those 4 rights which are mentioned in subclause A, B, C, D. Because as far as this extent is concerned, it is our case that these two provisions are interconnected. Per se, Milos, they are interconnected as a matter of birth. 25 gives birth to 26. Milos, what has Devaru done is, Devaru has directly established the interconnectivity between 26B and 25(2)b. If your Lordships appreciate, rights under 25 and 26 are inherently different. Because right under 25 is an individual right. Whereas when it comes to 26, it recognizes it, or it makes a subclassification called as a religious denomination or a section thereof. Right under 25 to an individual is a broad right. It gives an individual the right to practice, profess, propagate his religion, subject to a fact that it is a religious practice. Under 26, a religious denomination is being granted 4 exclusive rights. Now, my lords, the other part which makes these two provisions separate and distinct is Article 25 has 4 tests or has 4 factors wherein your lordships can intervene on those 4 grounds. That is 1, public order, 2nd is morality, 3rd is health, and the 4th is and the other provisions of this part. Because your lordships, while dealing with the question arising out of Article 25, can look at part 3 of the Constitution. Whereas, my lords, when it comes to Article 26, part 3 is missing there. I'll come to the part 3 in my second issue, my lords. But I am trying to demonstrate to your lordships the difference between the inherent nature of these two rights. The rights which is being awarded exclusively to a religious denomination, that is kept immune from part 3, my lords. Your lordships may note that. Now, my lords.
Now I have a question.
My
Now,
lords.
in 1958, when Devaru was decided, Maneka Gandhi had not been decided.
My lord.
So, Devaru proceeded on the assumption of Gopalan.
My lord.
Exclusivist thesis. Each article is an island kind of situation.
My lord, my lord.
But after Maneka Gandhi, you can't read articles in part 3 as separate islands. You have to also take into account the interactive dimensions of the constitutional articles. Therefore, can you really say that 25 and 26 are exclusive? And at any rate, in Devaru also, why this reference was made, why an attempt was made to carve out a small space for 26 was to just save few ceremonies wherein there should not be any intervention from the community. So the sancto sanctorum of the temple should be exclusively for the particular pujaris, right? But here we are talking about whole class of women. We are not here talking about a small discrete ceremony. So in light of Maneka Gandhi and in light of the factual difference between the Devaru and this particular case Sabrimala, how do you connect the dots?
When I say that the individual character of the right is different, I mean, my lords, as is similarly as can be seen in all provisions of part 3, my lords. Every provision is a little different than the other, though they may arise out of a similar heading or under a similar heading. That's even, my lords, while dealing with minority educational rights under 20. My lords.
One is individual right
My
of
lords.
a human being.
My
That
lords.
is also fundamental right to
My
profess
lords.
your religion. Right 26 to manage religious
My lords.
affairs.
My lords.
So I being an institute, I
My
am
lords.
also having a fundamental right to manage my affairs
My
in
lords.
my religious faiths.
My lords.
Right?
My
And
lords.
you are having, being an individual, you are also protected. You had been given also a right to profess your religion.
My lords.
So now whether you are going to take that religious institution's fundamental right away.
Your lordship, my lords, this is my case. With utmost respect, my lords, when Devaru says 26B be read in harmony with 25(2)B, Devaru establishes an interconnectivity. Devaru reason, or the reason which is being given under Devaru is that a harmonious construction of the two provisions shall be done. But, my lords, the core issue then remains. Can harmonious construction take away the individual character of every provision? My lords, to answer my Lord Justice Jain's question, my Lord referred to Maneka Gandhi. My lords, therein your lordships held that every provision has to be construed in a particular way or a harmony has to be established in part 3. But, my lords, that does not mean that individual character of every right is lost. My lords, it is our case that if Devaru is accepted to be continued, my lords, then the interplay that the Devaru has established is against the core principle upon which 25 and 26 themselves are built. This is the core submission. My lords, the second point which your lordships may appreciate, Article 26 within itself accommodates the religious denominations, irrespective of religion, which may include every religion. But, my lords, Article 25(2)B talks only and only of sections of Hindus or of Hindu religious institutions. If your lordships give it a meaning that 26b be read with 25(2)b, because what about the other religions that are covered under 26? And neither have your lordships in Devaru drawn a line. So, my lords, that has to be done. This is one. Second, my lords, when your lordships test the right under 26b in pursuant to 25(2)b, that is to say, now your lordships are opening the gate to part 3 of the constitution, which according to us is not permissible as per the language of the provision, my lords. The language excludes the application of part 3. 25(2)b is an element of part 3. So if an interconnectivity which the Devaru has established is allowed to be continued, my lords, that takes away the fact, or that directly affects the fact that 26 is immune from part 3. Therefore, my lords, with utmost respect,
by way of implication, that should be understood or interpreted then. In 26, it is not expressly provided, but we can get the spirit of it from Article 25. So whether we should get it by way of implication that it is also existing in 26, that way, not expression, but by way of implication.
Because in fact,
and secondly, sorry to interrupt, under Article 14 it gets into this umbrella, every single citizen of India. So under the guise of religious denomination which you are trying to practice under Article 26(2)b, you are in a way defeating the very purpose of Article 14 also. Together, and you have to read Article 14 together with 25. It has to be conjointly read. It cannot be read in it cannot be read in isolation. So under the guise of this religious denomination, by restraining a particular lady of reproductive age to enter into the shrine, you are not only defeating the purpose of Article 25(2)b, wherein she has the right of practicing her own religion, plus also you are defeating second constitutional fundamental right in the form of Article 14. So how you are going to address this particular issue?
It is our case that as soon as right under 26b is established, then subject remains regarding part 3 cannot be dealt or cannot be looked into. I'll try to satisfy this when I'll be dealing with issue number 3. But my lords, as was being pointed out by lordship, your lordships may appreciate 26 within its language, and even I'll point out to the Constituent Assembly debates, my lords, does not accommodate part 3. Your lordships may appreciate the question regarding Article 14 would arise when a question in 25 would arise. Plus 25, when it comes to individuals, then one can come in a claim that it is now violating right of equality. Plus 26 is an exclusive right that is pertaining only to a religious denomination. Now, as far as practices of religious denomination is concerned, and we are going to make our case on the other following issues, that as far as a right of a religious denomination is concerned, once a religion is established or once a practice is established as a religious practice, it is immune from part 3.
Sorry, I have a very fundamental question. Is Article 26(2)b is also subject matter of challenge in your petition? Is Article 26(2)b, which is the backbone of the entire controversy, is also subject matter of challenge in your, because unless and until that particular article is being upset by the Supreme Court, I beg to defer that other rights which is protecting this, you cannot be upset that. Because these rules are culminating of that Article 26(2)b. Article 26(2)b is an umbrella, wherein these rules which are being formulated by the state government or state legislature is culminating out of that particular umbrella. So unless and until the parent act is being upset or being questioned, these rules cannot be questioned.
As far as challenge is concerned, if your lordships look at the language, the plain language of the issue which is before the Honorable Court, it says interplay between Article 25 and 26. So, my lords, it is my humble submission that it covers the entire aspect of Article 25. And now your lordships.
Counsel, I have a question. Considering all your arguments as of now, considering, Articles 25, 26, everything into account. Now there are many other practices also. Religious practices in the country. For instance, even there is a practice of human sacrifice. So whether these kind of practices should be allowed without judicial review?
My lords.
Will it serve the purpose? Will it serve the basic fundamental principles laid down
My lords.
in Articles 26, 25, when there are certain exceptions which are clearly mentioned?
My lords.
And now I want to highlight also
My lords.
that the judgment of Navtej Johar,
My
which
lords.
was decided by five judges bench
lords.
in
My lords.
2018,
My lords.
which considered that the constitutional morality should prevail over such other,
My lords.
social, faith.
My lords.
So what is your submission to that?
Well, as far as constitutional morality aspect of it is concerned, my lords, we are going to deal with the same in our subsequent issues by the subsequent speaker. Now, my lords, as far as your lordship's question was whether such a erroneous practice is immune to judicial review, my lords, it is with utmost respect our case that your lordships or any religious practice is subject to judicial review by this honorable court. Now the subject remains, what is the scope and extent of such judicial review? It is our humble submission, and even if your lordships look at issue number 3, that while dealing with questions arising out of Article 26, your lordships have 3 options. That's 1, public order, health and morality. Now my lords, subject remains how is morality to be construed, that will be dead by my learned co-counsel. But my lords, as far as application of part 3 is concerned, it is our case that the provision does not accommodate part 3, that's 1. Second, my lords, the Constituent Assembly debates never said, my lords, your lordships may appreciate, the original text of the Constitution, Article 20 back then, did not include either public order, health or morality. My lords, Dr. B.R. Ambedkar, he later introduced these words by way of an amendment. Now, my lords, the reason that the Constituent Assembly did not include these words were, Dr. Ambedkar and the drafting committee assumed that the mention of public order, health, morality and other provisions of part 3 in Article 25 will impliedly have an application on 26. Then, my lords, Dr. Ambedkar felt it necessary that such an implied application would have hazardous repercussions. Therefore, he then proposed an amendment. By way of an amendment, my lords, these 3 words were included in under Article 26. Now, lordships may appreciate, if Dr. Ambedkar at that given point thought that implied application is not permissible, hence he introduced it by way of an amendment. My lords, your lordships may appreciate, he did not introduce part 3 to 26. That's 1. My lords, second is, not only Dr. Ambedkar, but none of the respectable members of Constituent Assembly talked of introducing part 3. My lords may appreciate, not a single attempt was made during the Constituent Assembly debates to include provisions of part 3 under disguise of 26. Therefore, my lords, it is my case that your lordships, while dealing with rights under 26, may not look at provisions of part 3 for the purposes that it would then enlarge the scope or it would then disturb the basic principles on which Article 26 stands today in our Constitution. That's 1. Because I have less time, I'll quickly sum up in 5 minutes.
I have just one suggestion, counsel.
My lords.
As this is the very complex question of rights.
My lords.
And to dealing with such situation, one thesis was proposed by Professor Hofeld, an American jurist. He has said, when there is a complex question of right must be declassified into the claim, privileges, liberty. And you have to consider whether in Article 25 we are dealing about the claim, whether in 26 we are dealing about the privileges, what is the actual positions. We are discussing only about the right, but this is the complex question. We have to find out whether in 25 individual is claiming, whether in 26 religious denomination is demanding privileges, what is actual the position. If we are going into the deep directions of the rights which was proposed by Professor Hofeld, then only I think we can come out with a clear picture. That is just my suggestion. You may have some comment on the same point.
As far as justiciability is concerned, or the scope and extent to which such a practice is to be tested by lordships, this is going to be the submission of my learned friend, who is going to deal with justiciability in his upcoming issues. Now, my lords.
Query I just wanted to ask. whenever you are saying about Article 26,
My lady.
don't you think it is subjective to Article 25?
My lady may appreciate. That was the heart. That is the heart of the issue.
Words that are used under Article 26, public order, morality and health.
My lady.
Don't you think it is, Article 25 overrules Article 26?
My lady may appreciate. With utmost respect, when it comes to overruling, it is my submission that it does not. Now the heart of the issue before this honorable court is whether there is an interplay. As was submitted, that 26 is born out of the womb of 25. But later, when it comes to the implication of the same, 26 applies entirely differently than 25 because it creates a subclassification. Now as was pointed by my lady that there are these three words which are similar in 26. My lady, these are the grounds on which these honorable courts may test right under 26. But the issue before this honorable court is, can we go and refer to part 3 in addition to these three words? On which my submission is that one cannot for a reason of the plain reading and the Constituent Assembly debates. That's one. Now my lady, I'll come on, your lordships, I'll come on the second aspect of my argument on 26, which is very essential. My lords, in Shirur Mutt, and I'll be quick, my lords, in Shirur Mutt, your lordships found a distinction between religious practices and secular practices. And in doing so, your lordship used the word integral or essential. Now my lords, I'll quickly emphasize a little. My lords, your lordship stated that in a religion, there might be practices which are not religious, which may be political, secular, etc. For example, if we are to run a temple, we may have to maintain the accounts, we may have to appoint certain watchmen, we may have to disburse their salaries, etc. These practices, your lordship said, need to be separated from the religious practice. And in doing so, your lordships used the word integral or essential. Later, my lords, in Dargah Committee Ajmer, a 5-judge bench of this honorable court took the reference of those two words, essential and integral, and stated that there shall be something or a test of essential religious practice. Because they have relied upon Shirur Mutt. In my humble submission, Shirur Mutt did not use those two terminologies, that is essential and integral, to say that there shall be an essential religious practice, but such usage was made to an extent of making a separation between religious and secular practices or other practices. That's one. Second, my lords, last point is, to sum up it in one line, my lords, it is our case that practices that are purely religious, one. Second, practices that do not hit public order, health and morality are protected under 26 even if they are not essential religious practices. Because that's all. For paucity of time, I may pause here, my lords. I would hand over to my second speaker. Much obliged, my lords.
So long and short of your submission is that 25 and 26 have to be read harmoniously.
My lords, it has to be read in a way to protect the individual sanctity of every
So
right.
therefore it has to be read harmoniously.
Because harmoniously is already being read by lordships in Devaru. It is my case that if it is done so, then it disturbs the very purpose of 26B.
My lordships, I will be dealing with issue number 1 and issue number 5 on behalf of the petitioner. The issue number 1 is in regards of scope and ambit of freedom of religion as enshrined in the Article 25 of the Constitution. On the other hand, issue number 5 is in regards to scope and extent of judicial review in regards to the freedom of religion in Article 25. My lordships, starting with issue 1, the Article 25 Clause 1 of the Constitution gives freedom of conscience and the right to freely profess, practice and propagate religion. And it is given to all persons subject to public order, morality and health and the other provisions of Part 3. My lordships, now to understand the ambit of freedom of religion, one should understand what is religion. My lordships, if you may come to page number 4 of my compendium, the compendium of petitioner 2. My lordships, in the case of SP Mittal versus Union of India, Justice Chinnappa Reddy states that everyone has a religion. In the para 2, my lordships, para 2 in the second line. Everyone has a religion, or at least a view or a window on religion. Be he a bigot or a simple believer, philosopher or pedestrians, atheist or agnostic, religion, like democracy and equality, is an elusive expression which everyone understands according to his preconceptions. What is religion to some may be pure dogma to others, and what is religion to others is pure superstition to some others. My lordships, further on the next page, in para number 4, Honorable Justice further states that religion is not to be confined to traditional...
Which justice you are quoting from SP Mittal?
Justice Chinnappa Reddy, my lordships.
Has he written majority opinion or dissenting opinion?
Dissenting opinion, my lordships.
So how do you rely on dissenting opinion? What presidential value dissenting opinion has?
My lordship, I am not relying on the ratio. I am relying on the legal principle as to what is religion.
But how can you rely on a dissenting judgment to infer a legal principle?
My lordships, I rely on the legal principle on how the religion should be inferred. The majority opinion also inferred the religion in the same sense, as the religion should be interpreted in the widest.
You could have said that majority and dissenting opinion both are important, right? But you are starting with dissent, and then after my question, you are alluding to majority, right?
My lordships, I apologize. For the understanding of the honorable bench, I have used the wordings of Justice Chinnappa Reddy as it aligns with my contentions more clearly.
No problem. Please proceed.
Yes, ma'am. Honorable Justice further states that religion is not to be confined to the traditional, established, well-known or popular religions like Hinduism, Mohammedanism, Buddhism and Christianity. There may be, and indeed there are, in this vast country several religions less known or even unknown, except in the remote corners or in the small pockets of the land where they may be practiced. A religion may not be widespread, it may have little following, it may not have even a name, as indeed most tribal religions do not have. We may only describe them by adding a suffix of ism to the name of the founding teacher, the tribe, the area or the deity. Hence, my lordships, the word religion should be interpreted in the widest manner possible, where every smallest religion or the very smallest community of beliefs should be considered in religion. Now, my lordships, the question here arises that how is the religious activity to be conferred in the ambit of the religion? My lordships, relying on the Shirur Mat, it says that the religious activity should be seen from the etymological sense, meaning that the religious activity should be in adherence with its origin. Hence, it should be in alignment with the historical development of that activity. My lordships, to further elaborate this contention, I may take the examples of 3 major religions in our country. My lordships, first I'll start with Hinduism. My lordships, citing Mahabharata in Varna Parna in chapter 17, Shlok 117, when Yaksha asked Yudhishthira, what is dharma? To which Yudhishthira replied, Turko pratishtha shkrutya vibhinnam, neko rishi yasya matam pramanam, dharmasya tattvam nihitam guhyam, mahajanayana gata sapanta. My lordship, this literally translates to formal logic is vacillating or inconclusive. The sacred scriptures of Shrutis are contradictory or diverse. There is no single rishi whose opinion can be considered the final or sole authority. The true essence of principle of dharma is hidden deep within caves. Therefore, the path followed by virtuous or great person is the only proper course to follow. Now, my lordships, here a believer of a Hindu religion has been given liberty to follow the person who he considers has been following the right path. Hence, my lordships, the liberty in Hindu religion is very wider compared to other religions, my lordships. Hence, the ambit in which the religious activity of Hinduism should be decided should be much wider. My lordships, to cite the contrary, speaking of origin in Islam, I'll cite the Surah Al-Ikhlas, which is in Sipara 30th of the Quran. It says, Kul hu Allahu ahad, Allahu samad, lam yalad walam yulad, walam yakullahu kufuwan ahad. Meaning that He is Allah, one, The Allah is eternal refuge, the absolute. He neither begets nor is born, nor is there to him any equivalent. Further, in the Kalma of Islam, it is said, La ilaha illallah Muhammadun Rasulullah, meaning that Allah is one and Muhammad is his only messenger. My lordships, now construing the religious activities in Islam, it cannot be contradictory to the origin. One person following religious activity in Islam cannot follow a person who does not follow Allah. Hence, my lordships, the religious activities in Islam should be construed in the ambit of the tenets of the religion or the basic doctrines of the religions of Islam. Similarly, in Christianity, my lordships, in John chapter 17, para 3, it is stated that Christ, while looking at heaven, says that, Father, the hour has come. Glorify your Son, that your Son may glorify you. For you granted him authority over all people, that he might give eternal life to all those who have given him. Now this is eternal life, that they know you, the only true God, and Jesus Christ whom you have sent. My lordships, in the religions like Islam and Christianity, the origin lies with the fact that there exists one God and one true messenger. Hence, any activity which is of religious nature contradictory to the origin of that religion should not be protected under 25. Only the religious activities which are in alignment with the basic tenets of the religion and the basic doctrines of the religion shall be protected. Hence, that is where the extent of the protection is to be decided. My lordships, further coming to Article 25, Clause 2, Subclause A, which grants power to the state to form legislation regulating or restricting any economic, financial, political or other secular activities which may have been associated with religious practice. My lordships, relying on the Shirurmat case, where the secular activities were considered distinct to religious activities on the ground that a religious activity should be integral and religious part of the religion. Hence, my lordships, the limitation on the state exists only to regulate the activities which are not essential and integral to religion. And what is essential and integral to the religion should be construed in the way in 25.1, which has been contended by the petitioner. Lastly, my lordships, speaking of Article 25, Clause 2, Subclause B, which speaks of providing for social welfare and reform or the throwing open of Hindu religion institute of the public character to all classes and sections of Hindus. My lordships, my learned co-counsel will be dealing with this part of Article 25. But to be very concise, my lordships, the phrase sections of Hindus is to be interpreted in the widest manner possible, which includes every classification and every subclassification. The Honorable Court has held this in multiple judicial precedents in the past. Though, my lordships, it is to be noted that it deliberately includes other religions such as Islam and Christianity, as it is the duty of the personal laws of that religion that governs the classification of those sections. And it can be seen in the constitutional debates as well.
School of thoughts or so-called doctrines which have been practiced since time immemorial should be allowed to be practiced irrespective of the fact that it is completely violative of Article 14 and so on and so forth.
No, my lordship,
So these so-called doctrines are being followed without there being anyone who is in support of this particular doctrine. No one has stepped into the witness box to support this. No one has been cross-examined regarding this particular, whether these doctrines are right or wrong. No one has been. These doctrines have not been subject matter of any kind of a trial. There is no fact-finding exercise which has been carried out insofar as this particular doctrines. So your contention is that irrespective of the fact that there had been no fact-finding exercise with respect to this particular doctrines, and irrespective of the fact that these doctrines are violative of Article 14 and 16, Article 14, these doctrines should be propagated in future also. Is that your case?
My lordship, it is humbly submitted that, my lordships, there are two aspects as you have spoke of. One is it subjected to the Article 14 and 16 of the Constitution? My lordships, right now I speak of freedom of religion as per Article 25. And my lordships, the text of article itself says that it is subjective to the Part 3 of the Constitution. Hence, my lordship, it is subjective to 14 and 15. So, my lordships, my case is that yes, freedom of religion is subjected to Part 3 of Constitution when it speaks of individuals' right in Article 25, which the issue is. And my lordships, the second aspect which you spoke of, the fact-finding aspect. My lordships, if you may accommodate me for few moments, I'll be dealing with the same issue when I speak of issue number 5 of the
Council, I have just one question. Yes, please.
I have a question. When you talk about religion, you talk about the historical development and certain practices being followed from time to time. Now, considering that aspect, you know, this court has held in many of the cases that any practice which violates the fundamental right of a citizen cannot be protected. Now, for instance, if we talk about the historical development and the practices in triple talaq that this court decided in 2017, that was also a similar kind of a practice for all the years together. But still, this court struck down that practice, considering the same articles you referred, like 25, 26. Similarly, also, like there was a, you know, Tandava dance in public, that was also struck down in 2004. So considering these aspects, how your case is different?
My lordships, the issue in front of the honorable bench is the scope and ambit of freedom of religion as enshrined in Article 25. It only speaks in the strict sense and boundary of Article 25. And my lordships, the practices and the religious practices in Article 25 are subject to Part 3 of the Constitution. Hence, my lordships, presently, particularly in this issue, I do not contain any religious practices as per Article 26. And every religious practice as per Article 25 is subject to the Constitution of India.
Now, Council, if you read the language of Article 25, right, there are two words which are very important: all persons and equally, right? So, don't you think all persons would include women, and therefore women would also be entitled to enjoy their religious right equally with men? I mean, staying with you on the scope of Article 25 itself, would you argue that no, the scope of freedom of religion is different for women than men, and even if there may be some discrepancy, let the religious community decide it, court should not intervene into it?
My lordships, firstly, the case of the petitioner is that the fact-finding court should decide what is a religious practice and what is not a religious practice. Hence, the judicial review should be allowed. Secondly, my lordships, the word equally, as mentioned in Article 25, my lordships, religious equality is very different from any other form of equality. My lordships, currently, if I, just to draw an example, my lordships, if I speak of economical equality, let's say me and my learned friend find 1 lakh rupees. And if I divide that equally between me and my friend, it would be said to be economically equal. But my lordships, two people sitting in the same temple in front of the same deity at the same time cannot be said religiously equal for both the persons. Hence, the value of religion can be different for two different people. Hence, religious equitability should be discussed. And my lordships, the particular case that the honorable, your lordship pointed out of Sabrimala, in that case, my lordships, the religious equitability of the women lies in practicing their religion by not entering in the temple. Though, my lordships, the reference may be drawn to Sabrimala, that is not the present question before the honorable bench.
Yes, Council. In your petition only, you have argued that the concept of Hinduism has a very wide scope. But on the other side, you are insisting this bench to find out the scope of Hinduism in respect of essential religious practice. Don't you think that it is a contradictory argument put forward by you?
lordships, the scope of religious practice in Hinduism is a wide scope, but yet it is still subjected to the constitution as per Article 25. Hence, my lordships, when I speak of Hinduism, the religious practice can be in alignment with the doctrines of Hinduism, but it should also be in alignment with the Part 3 of the Constitution, my lordships, as per Article 25, strictly in the boundaries of Article 25.
Mr. Counsel, now there is religious practice, an essential religious practice. When we are debating upon all the while, we should confine to the petitions which are coming up before Supreme Court, laying down principles on the basis of which we say that these are the citations being followed by us. Now, if it be so, then essential religious practice, whether that can be the sole feature for resolving the issues coming up, or is there something beyond that? Now, I, with request to my learned brothers who are presiding, whether there should be any phenomenal change or some principle to be laid which goes beyond what has already been decided and being prevailed by the judgments of the Supreme Court, such as essential religious practice. Have we to go beyond that by applying some phenomena which is universal? That is to be thought upon.
Precisely, my lordships. My lordships, I'll enumerate more on that thought in the issue number 5 of the matter. So, my lordships, if you may accommodate for a few more minutes, I'll speak on the question. My lordship, I shall start with issue number 5 of the matter, which is in regards with scope and extent with regards to the judicial review, with regards to the religious practice as referred in Article 25 of the Constitution, specifically the Article 25. My lordships, the current test, as your lordships rightly pointed out, the current test of essential religious practice as applied by the higher judiciary inadvertently risks standardization of faith by treating the question of what is essential or what is a religious practice as a pure question of law. My lordships, the petitioner contends that what is essential is a fundamental question of fact or a mixed question of fact and law, where there is a rigorous requirement of verification of evidence rather than judicial intuition. My lordships, in determining whether a practice is essential, it requires exhaustive analysis of scriptural evidence, historical continuity, and specific tenets of any section.
Shortly, you may satisfy us as to whether if any practice is to be determined, whether that particular issue should be referred to trial courts for being adjudicated upon, or whether by way of affidavits before Supreme Court, such issue should be assessed and concluded. And if it be so, then it will be, if it is referred to trial courts for being adjudicated upon, then whether it will stand as an endless quarrel. How we may conclude that? And how coordination can be sought by us, you believe?
My lordships, firstly, yes, it should be referred to the trial court as what is essential and what is, first of all, there needs to be examination of the experts. Let that be scholars, the religious heads, the tantras. There should be a rigorous examination. Secondly, there should be a verification of immemorial usage, whether the practice is to be considered a custom. And is the religious practice an essential religious practice that should be conferred with the texts of any religious scriptures. Hence, it should be it should go to the trial court, and the affidavits, my lordship, shall not be allowed because it does not pass through judicial scrutiny, my lordships. Hence, deciding upon an issue of basis on the affidavit which do not pass judicial scrutiny can lead to misleading facts, my lordships.
Mr. Counsel, I would like to just ask you one question. That what is the position of remaining temples of Ayyappa in all other parts of India? Because you are only talking about Sabrimala. But whether women of all ages are permitted in all other temples of Ayyappa? If yes, then why not in Sabrimala?
Precisely, my lordships. My lordships, women in all the other temples of Ayyappa community are allowed to enter. The only reason the barment of the women of age 10 to 50 exist is because of the nature of the deity, my lordships. The nature of the deity is of a celibate nature. Hence, to preserve the nature of the deity, women of that ages are not allowed, and that barment is completely temporary. Once the women crosses the age of 50, that barment stops. Also, my lordships,
after that only you are pure.
my lordships, it is humbly submitted that the present matter does not revolve around the facts of Sabrimala, but to answer the question of your lordship, the nature of the celibate nature of the deity should be considered. And because the consideration of the celibate nature exists, there also lies a restrictions upon men. They are kept in a premises for 40 days to make sure that all the impure thoughts are to be removed, and only after satisfaction that all the impure thoughts are removed in 40 days, meals are allowed. Secondly, as for females, my lordship, the question of purity does not exist, my lordship. The question of whether it is a religious practice as per the beliefs and the tenets of the religion is there. Hence, my lordship, it is not a question of purity, it is a question of religious practices as to the nature of the deity. If I may. Precisely, my lordships. My lordships, I conclude my arguments this way, saying that the question of fact should be dealt by competent trial courts, because it requires rigorous examination of evidence. It requires judicial scrutiny to analyze what is facts, and once that is done, then the question of law can be examined by the higher courts. I conclude my arguments. My co-counsel will continue from here. Much obliged, your lordships.
My lordships, I'll be dealing with the fourth issue, and I'll be predominantly answering the question as whether the term morality in Article 26 constitutes of a constitutional morality, whether it means constitutional morality or not. My lords, it's most humbly submitted in the beginning that it does not mean constitutional morality as of 26 is concerned. But my lords, in order to answer this question, we'll first need to trace where this word, the constitutional morality, comes from. Now, my lords, as far as the constitution is concerned, the only word which exists is morality. It is judicially interpreted as constitutional morality, and it can be traced back to the Constituent Assembly debates. Now, B.R. Ambedkar has mentioned this word a few times, and the only time when he is very clearly mentioning it and very clearly elaborating upon it is when he is actually responding to a query or responding to a criticism. He has been criticized on the matter that why has the Government of India Act, why is the constitution so heavily deriving from the Government of India Act. Now, it is important to understand that back then, no other constitution like the Constitution of India had such procedural intricacies into it. As of the Constitution of India is concerned, we give a lot of procedural intricacies as to the appointment of Council of Ministers, so on and so forth. It was not there in any other constitutions, and that is why this criticism was being put forth. And he is answering, and he is giving the definition of constitutional morality as to answering this question. My lords, may please refer to the third page of my compendium. It has been highlighted, my lords. I proceed? Oh, bless your lordships. He says, and I quote, as to the accusations that the draft constitution has produced a good part of provisions of the Government of India Act 1935, I make no apologies. There is nothing to be ashamed of borrowing. It involves no plagiarism. Nobody holds any patent rights in fundamental ideas of constitution. What I am sorry about is the provisions taken from Government of India Act 1935 relate mostly to details of administration. I agree that administrative details should have no place in the constitution. I wish much that the drafting committee could see its way to avoid their inclusion in the constitution. My lords, now he is quoting constitutional morality in the eyes of Grote, as Grote quotes it as constitutional morality is a paramount reverence for the forms of the constitution, enforcing obedience to authority acting under within these forms. My lords, now you may please scroll down, and I quote, the other is that it is perfectly possible to pervert the constitution without changing its form by merely changing the form of administration. Now, my lords, what he is trying to tell is that the constitutional morality has to come into picture wherein a state will act in a perverted manner because there is a vacuum in the constitution, because there is a loophole that the state can exhaust. And when such loophole exists, when the constitution particularly doesn't direct state to do something, in order to ensure that the state then acts in a legitimate manner, he then adds constitutional morality. It should act in the light of constitutional morality. This is the sense in which he is using the term. And my lords, the same context has been also used in the case of Manoj Narula. My lords, I'll just briefly tell you the facts of this case. So the court, while respecting separation of powers, had at the end of the day said that...
Still, see, Manoj Narula, we are aware, right? The issue is, why do you say that morality and constitutional morality cannot go together? Because constitutional morality simply means that we should have reverence to the constitution, we should respect the constitution. We should have faith in the principles underlying the constitution. And one of the most important principles underlying the constitution is gender equality. And don't forget that we have Article 15(1) also in our constitution, which prohibits inter alia discrimination on the ground of sex. So what is the problem in reading morality and constitutional morality together rather than seeking a divorce between the two?
Much obliged, your lordships. May I answer this?
Yeah, to sum it up, maybe to make it more simpler, I can simply ask whether any morality whatsoever can justify the discrimination of women when Article 14 is applicable. She has equal rights, she has all the fundamental right given as a citizen of this country.
My lords, as of Sabrimala is concerned, I'll answer that question, but firstly answering...
I mean, when we talk about morality, we justify the discrimination at the same time. So where is the morality then?
Well, as the morality there is not based on the discrimination. It is based upon, in Sabrimala, it was based upon the characteristic of that god. It is based upon the perception of morality for that particular religion. And then again, it has nothing to do with the discrimination of women per se. My lords, I have used constitutional morality in this context, and I have quoted Manoj Narula, and I was going to quote Navdeep Singh Johar as well. My basic contention is that constitutional morality has been invoked in contexts where the issue was very broad. Issue was broad as to the vacuum of the state, broad as to 377, the rights of certain people. But my lords, when we talk about Article 26, we are discussing a very narrow right. We are discussing the right of a religion in that a religious denomination, the autonomy of that religious denomination. So my lord, the right is very, very narrow, and the application of constitutional morality, when we use it, it is implied that it has to be used in a broad context. So this does not fit. That is my basic contention, my lords. And
Counsel,
yes.
yeah, in that context, I would like to ask you that is there any religious morality which is totally different from constitutional morality?
Yes, my lords, the religious morality shall be driven from those the ideas of that religion per se. Whilst we say constitutional morality, there comes a straight jacket formula of having to adhere part 3, adhere to the equality principle, adhere to the principle of Article 19. But when you talk about the morality of a religion, that whatever the religion is centered towards, for example, in Sabrimala it was centered towards that particular god. So the morality for that god was given preference because that was necessary to preserve the characteristic of that particular god. So yes, there is a difference, my lord.
You must be aware of one concept by the name of casus omissus. The courts cannot be allowed to read something which is not mentioned in the legislation or the constitution. Now, going by the tenor of Article 14, 16 or 25 or 26, it's completely gender neutral. It's not gender bias kind of articles. So if at all you are trying to read that there can be discrimination which can be permitted under the garb of 26, you are making it gender biased. And so how do you basically say that this practice of yours is passing the test or qualifying the test of constitutional morality, wherein all these provisions are completely gender neutral? It's absolutely not gender biased. So how do you say that this particular test of the practice of yours is passing the test of constitutional morality?
Malas, this question has to be answered case specific. May I please answer it in context of Sabrimala?
I am saying that because it's not this particular provision under Article 25 is not excluding women per se.
Yes.
Article 14 is not excluding women per se. Article 26 is also not excluding women per se. Maybe of any age, by between 15 to 50 or whatever, it's not excluding per se. How would you allow the court to read something which is not there in the constitution? That's the question. Maybe it's a kind of a void, but whether the courts can be allowed to fill up that particular void, whether if at all it's a loophole according to you, whether the courts can be allowed to fill in that particular gap, which according to the principle of casus omissus, and if you read the judgments, the courts are not allowed to read something which is not there in the constitution or which is not there in the provision.
Malos, the vacuum which you are mentioning is to be filled by constitutional morality, and that is my contention that it is not constitutional morality in Article 26.
Same is counsel. Morality existed even when constitutional setup did not exist.
Yes, ma'am.
And some principles prior to constitutional setup are still being observed by us as morality. So that is a morality which is coming as it is a perpetual thing. Now beyond that, if socially that does not get recognition, or say state is coming with such role which is perverse, if there is perversity in the approach of the state, then we get the monitoring rod of constitutional morality. So constitutional morality must override over all moralities, and if morality is questioned and dispute arises, then from the standpoint of constitutional morality, it is to be concluded. There cannot be any other radar for assessing that.
My lords, but when
These are the two distinct factors, morality and constitutional morality. Lastly, we come, now if I presume that I have a right in a plot, then somebody says that he is disputing, saying you don't have any right. Now these rights are to be referred to court. Then court shall apply its own rules and redress the issue. Exactly in the same way, morality exists, but as per my perception, it exists. But if there is to be required a recognition, some establishment, then within the framework of constitution, lastly it is to be scrutinized. This is the distinction between morality in general and constitutional morality.
Much obliged, your lordships. My lordships.
Please continue.
So my lord, my contention was it should not be read as constitutional morality, and I will answer you otherwise. If it is read as constitutional morality, what will be repercussions of the same? I will elaborate upon this, my lords, so as to satisfy this bench. My lords, firstly, let us take the example of Sabrimala itself. Now, if we are to allow a woman to enter a temple, enter a certain temple, which bans the entry of a woman on the basis that there is a certain nature of that celibate deity, and that celibate deity's nature has to be preserved, But under the banner of constitutional morality, if we are letting that woman enter that temple, are we not extinguishing the right of that deity or the right of that religious denomination under Article 26? So you have to strike a balance, my lords. The balance is not struck. You cannot extinguish the right of Article 26 in order to uphold constitutional morality. That is clearly not the intent of the makers of constitution. That will make Article 26 completely infructuous, which is again not the intent. Well, secondly, under the umbrella of Article 26, there are very many religious practices which still exist, and I may name some. Firstly, the practice of self-flagellation. Lordships, there is a lot of bodily hurt in that context. It obviously goes against Article 21, but it still exists. Secondly, the practice of santhara, again Article 21 has been breached, but it still exists. So, my lords, there are very many practices which are existing under the autonomy of Article 26. So, if we are to superimpose constitutional morality here, we are hurting those practices and without the intent of doing so. Now, my lords, lastly, and my very important contention is, again we go back to Sabrimala. So, my lords, when we give entry of women to enter particular temple under the banner of constitutional morality, saying that they have a right under Article 15, Article 14. Now let's assume that this temple is open to all women, yes. But then wasn't this the very distinction of that temple, that the deity there is celibate? That is the distinction of that deity. At the sanctum sanctorum of secularism of India lies this diversity. We do not wish to homogenize all religions. We wish to preserve that very diversity, and it was preserved by Article 26. But if you let the woman enter, not just woman, if you let any man who has not followed that penance which is expected, that of 45 days, that penance which is expected, if you even let him inside, then what will be the difference between that temple and any other temple out there which allows entry to anyone? Aren't we trying to then homogenize all religions? And how much homogeneity will we bring then? Isn't this killing the diversity, my lords? That is my contention. That is my basic and primary.
Very narrow, between 25 and 26. You don't want to involve Article 14, Article 17 rights. You want to keep it only between 25 and 26, right?
Yes,
you are having goddess like Saraswati, you are having goddess like Lakshmi. But you want to keep, you don't want to make it homogeneous according to you.
Yes, ma'am. Yes. That is my primary contention. Now, if your lordships are satisfied, I'll move forward to my next issue. Yes, your lordships. May I move forward to my next?
Please continue.
Obliged, your lordships. My next issue deals with the term, the expression, or the meaning of expression sections of Hindus. Now, my lords, in order to understand the grasp of sections of Hindus, it is firstly necessary to understand the definition of Hindus per se. Now, the term Hindus is not being defined in our constitution anywhere, but it can be drawn from the judgment of Shastri Yajnapurush ji versus Muldas, and you may please see page 130 of my compendium, my lords.
Are you sure that the term Hindu is not defined in the constitution? What is explanation 1?
Yes, my lords, that is not an... I was
Can
going
you read
to
explanation 1 from the Bare Act?
Just a minute, your lords. Explanation 1 of Article 25. The wearing and carrying of kripan shall be deemed to be included in the
second explanation, sorry, I may be wrong on number.
Yes, the subclause B of clause 2, the reference to Hindus shall be constructed as
so what is this? Is it not the definition of Hindu?
Yes, my lords, I was going to elaborate upon this. I was going to first establish that...
because you made a statement that constitution does not define Hindu, right?
I apologize in that context, my lords.
Okay. Please continue.
No, it is inclusive definition. It is not.
Yeah. So my brother is giving you concession. Continue.
That is there. What is?
I agree. Continue.
Yes. So, my lords, it defines Hindus in this judgment. The definition has been given, and I may quote: when we think of the Hindu religion, we find it difficult, if not impossible, to define Hindu religion or even adequately describe it. Unlike other religions in the world, the Hindu religion does not claim any one prophet, it does not worship any one god, it does not subscribe to one dogma, it does not believe in one philosophic concept, it does not follow any one set of religious rites or performances. In fact, it does not appear to satisfy the narrow traditional features of any religion or creed. It may broadly be described as a way of life. It is further stated that Hinduism has steadily absorbed the customs and ideas of people with whom it has come into contact, and has thus been able to maintain its supremacy and its youth. And then, my lords, the paragraph comes, which you may please refer to, page 133, paragraph 37. The development of Hindu religion and philosophy shows from time to time that saints and religious reformers attempted to remove from the Hindu thought and practice elements of corruption. So Buddha started Buddhism, Mahavir founded Jainism, Basava was the founder of Lingayat religion, so on and so forth. So, my lords, this itself states that the definition of Hindus is very broad. The definition of Hindus is very broad, and it cannot be confined. And, my lords, this has been reflected into the terms sections of Hindus, when it says sections of Hindus, and even in explanation too, my lords. So, now coming back to the actual clause of sections of Hindus, my lords, this clause is very important. It does not say section of Hindus, nor does it say sections of Hindus. It is not construed in any other manner, but in manner sections of Hindus. It's used in a plural sense. And the intent, we can understand the intent of this from the Constituent Assembly debates. And my lords, may please come to my compendium. My lords, just a minute. The argument of K.T. Shah, my lords, and the argument of Durga Bai, page 109 of compendium, my lords. If I may read it out. My lords, Srimati Durga Bai is the one who had moved the amendment. She says, and I quote, "Mr. President, sir, I beg to move the following amendment, that in subclause B of clause 2 of article 19 of the words any classes or sections, the word any classes and sections must be substituted. Sir, my amendment is accepted." The clause would read so and so. Sir, the object of my amendment is to enlarge the scope of the clause as it stands. The clause as it stands reads thus: for social welfare and reform or throwing open Hindu religious institutions of public character to any class or section of Hindus. That was the original. Sir, my view, she says, and I quote, "Sir, in my view, the clause as it stands is restricted in its scope. The object of my amendment is to secure the benefit in a wider way and to make it applicable." If my lords may permit, I may please continue. Much obliged, your lordships. My amendment is to secure the benefit of a wider way to make it applicable to all sections and classes. Sir, though we are not able to make a sweeping reform or a more comprehensive reform in this direction, I feel no distinction of any kind should be made between one class of Hindu and other classes of Hindus. So, my lords, this means that it necessarily has a historical context to it. They were trying to incorporate all sections of Hindus. In a sense, they were trying to incorporate the historical discrimination that had been faced, and now they are trying to bring them all under the banner of Hinduism. This entire definition. Another thing I would like to quote, my lords. K.T. Shah, if you scroll up, there was a suggestion made by K.T. Shah, and he said we should add the word Christians into the definition. That was not accepted, as we can see from the current language. So, my lords, we can understand. When we say sections of Hindus, we are necessarily talking of all sections of Hindus in terms of sects, in terms of subcastes, in terms of creed, and not in terms of gender. Never was there an intent to add gender into this, my lords. In fact, it does not contemplate gender at all. It is a gender neutral term. So, my lords, when it comes to sections of Hindus, it has to mean...
Very creative argument, impressive. But can you elaborate on the value of Constituent Assembly debates while interpreting the Constitution, particularly when the language of the article is not ambiguous, when it is unambiguous. And literally means, all sections means everybody, including both gender as well as the caste and creed and other things. So would you like to attach weight to Constituent Assembly debates? I mean, it's a very interesting argument.
My lords, as of the Constituent Assembly debates are concerned, we assess or we go back to
You are
Constituent.
only talking about 2 members. It's an opinion of 2 members.
My lords, but it was accepted by the entire assembly. As of Constituent Assembly debates are concerned, they speak of the intent of that particular act. And my lords, again, K.T. Shah had introduced the term of Christians. So if they were talking of gender at all, they would have added the term Christians, added any other religion, because then they would have obviously intended that gender equality, if they would have intended it that way, should be given to all religions. Why only Hindus then? So your lordships, as I was saying, that here sections of Hindus necessarily mean that all sects, and it does not include gender per se. Now my lords, going to the second part, social welfare and reform. My lords, this cannot be read in isolation. It has to be read in its context of historical discrimination. It must be understood in the same context. The purpose of this provision is evident as to Constituent Assembly debates when they were referring to a specific social problem in the Hindu society and they were trying to remedy that problem. So my lords, there has to be a line which has to be drawn. As to, now when we take, again my lords, I will come back to the Sabrimala temple. We cannot put the Sabrimala issue into the scope of social reform because it contemplates social reform. This article contemplates social reform, and we have propagated, yes, social reform has to. My lords, may I please continue?
So you can please conclude in 30 seconds, please.
Yes, my lordships. Apologies, my lordships. The primary contention is that there should be a line drawn between the theological reform and social reform. We are particularly talking about social engineering. That is to exclude these discriminations. But when it came to Sabrimala, we are going beyond our scope. We are not doing social reform there anymore. What we are doing is theological reform. We are changing the characteristic of a deity. It does not serve any social welfare. That would be my contention, my lords, if my lords are satisfied. Much obliged, your lordships.
If it please this honorable court, I would like to address issue number 7 of the issues framed. Before your lordships begin adjudicating these issues, it is critical to point out that these issues have been reframed by the Honorable Chief Justice Bobde before reference was made to this honorable bench. Your lordships, the petitioners would like to begin by firstly distinguishing the issues at hand, and secondly, by pointing out certain intricacies about how this issue should be interpreted. Your lordships, before reframing of the issue read, what would be the permissible extent of judicial recognition to PILs in matters calling into question religious practices of a denomination or a section thereof at the instance of persons who do not belong to such religious denomination. Here, your lordships, it is important to point out that the word practices is prefixed by the word religious, because Article 26B only protects religious practices, your lordships. After reframing, the issue now reads whether a person not belonging to a religious denomination or religious group can question a practice of that religious denomination or group by filing a PIL. Lordships, while construing this issue must be read, the word practices must be read as religious practices. Certainly, it is not the contention of the petitioners that all practices of the religious denomination, regardless of howsoever secular they may be or detached from the religious basis of that denomination, are outside the scope of public interest litigation. Secondly, Your Lordships, this issue must be construed in context of the petitions before this honorable court that have led to this reference. Your Lordships, if you may please turn to page 24 of the compendium before you, where the Honorable Chief Justice Gogoi has pointed out certain petitions where these issues have arisen. Firstly, obviously, the entry of women in regards to the Sabrimala temple. Secondly, the entry of women in mosques, and also the rights of Parsi women married to non-Parsis in the Agyari. Your Lordships, as it can be construed from this, the practices are all internally affecting matters. This means that they are all affecting the rights of the persons who are members of that religious denomination. This is important in understanding what is the right of a third party who is not a member of that religious denomination to file a public interest litigation. In this reading of the issue, Your Lordships, the petitioners put forth 3 arguments. Firstly, Your Lordships, allowing such PILs would be a grave threat to the autonomy of the religious denomination as granted under Article 26B of the Constitution of India. If Your Lordships may please turn to page 290 of the compendium before you, paragraph 23 of the judgment of Shirur Mutt. Do Your Lordships have it? Yes, Your Lordships, for the paucity of time, I'll read out the relevant portions of the judgment. The language of Articles 25 and 26 is sufficiently clear to enable us to determine without the aid of foreign authorities as to what matters come within the purview of religion and what do not. As we have already indicated, freedom of religion in our constitution is not confined to religious beliefs only. It extends to religious practices as well, subject to the restrictions which the Constitution itself has laid down. Under Article 26B, therefore, a religious denomination or organization enjoys complete autonomy in the matters of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold. Your Lordships,
Counsel, first of all, you have to cite the Supreme Court judgments on locus standi, right, rather than arguing the matter in abstract. And secondly, assuming for the sake of argument what you are arguing, suppose majority religion, now our constitution definitely makes a distinction between majority religion and minority religion, as is evident from Article 25, right? We have opened the temples, our temples. We have banned, we have banned embargoes on the ground of caste in temples, right? So we have a different position on majority religion. Suppose a majority religion tries to take into its fold all minority religions. Suppose majority religious institutions start gobbling up the space occupied by the minority religions. Then why somebody belonging to minority religion cannot challenge certain practice followed by the majority religion?
Your Lordships, as
because you are trying to say that if at all reforms have to be brought, somebody from the religion has to come before the court, right?
Yes, Your Lordships, because regarding the first issue, Your Lordships, these are all, as we have pointed out, these are all internally affecting matters. So the rights of the persons who are members of that religious denomination are impacted by the practices of that religious denomination. And it is in that context that the council is trying to argue this issue. And Your Lordships, about citing the expansion of locus standi, the council will come to that in the second argument, which is all about the historical development of public interest litigation, how locus standi was expanded and in what context. Your Lordships, as is clear from this point, religious denominations have the right both to determine what their practices are and to carry out those practices. Your Lordships, this very essence of the freedom of religious denominations under Article 26B would be undermined if public interest litigations are allowed to impose standards, external standards of rationality and modernity, which are foreign to the faith's core tenets. Coming to Your Lordships, the second point regarding the historical development of...
No, you did not follow my question. I'm not going to that direction. Is it foreign if I say that let men and women of a particular religion enjoy equal rights to practice religious rights, even if I don't belong to that particular religion? What is the problem?
Then Your Lordships...
generally, PILs are filed because there is a fear in the minds of the members of certain community. Maybe women of Ayyappan community are apprehensive, and therefore they need support from their other sisters.
So, Your Lordships, in regards to fear, this your argument, Your Lordships, if I'm understanding correctly, is that the fear constitutes a disability preventing this members of that religion from approaching this court. And Your Lordships, this is exactly the argument that will be dealt with in the argument 2 of the petitioners regarding historical development, Your Lordships. Okay, Your Lordships, it is the contention of the petitioners that PIL as a tool of judicial construction is created to ensure justice to those who have no other avenues of achieving it, Your Lordships. And if Your Lordships may come to page 161 of the compendium, in the case of Subhash Kumar versus the state of Bihar. Here, specifically, the court has outlined that the context in which public interest litigation expands locus standi. The court states, public interest litigation contemplates legal proceedings for vindication or enforcement of rights of group of persons or community which are not able to enforce their rights on account of their incapacity, poverty, or ignorance of law. Your Lordships, if I'm correct, that was the contention that Your Lordship was trying to make. Here, Your Lordships, the argument of the petitioner is that there is no, in a real sense, there is no disability on the persons who are members of that religious denomination. As far as fear is concerned, or social pressure that prevents them, Your Lordships, there are other ways to do away with this disability. For example, Your Lordships, this honorable court has itself allowed in-camera proceedings and filing of litigation anonymously in cases of rape or other sensitive matters. Your Lordships, when certain other avenues are available which may do away with the disability, then public interest litigation may not be allowed because that would make Article 26 infructuous, Your Honor. So all attempts must be made to do away with disability, if any. And secondly, Your Lordships, coming to the specific instances of Sabrimala or other instances, it is the contention of the petitioners that the reason why the persons of that religious denomination are not enforcing their right or coming before this court to enforce their right is because their own religious beliefs prevent them from doing so. It is their own religious beliefs that the practices of the religious denomination must be followed. In this instance, Your Honor, such religious belief of the members of that religious denomination cannot be construed to be a disability. And in this case, the council would like to cite, if Your Lordships will please come to page 168. The second line of the paragraph, in Karanjit Singh versus Union of India. We do not think such a contention is tenable. The disability must be one which the law recognizes. A mere obsession based on religious belief or any other personal philosophy cannot be regarded as a legal disability. Thus, Your Lordships, what is preventing the persons who are members of that religious denomination from approaching the court is their own religious belief, which does not constitute a disability to allow someone who is not a member of that religious denomination to file public interest litigation. Your Lordships, thus the most fundamental aspect of public interest litigation, that is the disability of the persons who...
Now Justice Brandeis has evolved a tradition in US, and we also follow it to an extent in India, which is known as Brandeis brief. So do you have any survey to suggest that, okay, it's not disability, but their belief which is preventing them? Have you, on what basis you are taking this position?
So Your
how can you
Lordships,
speak on behalf of the entire female folk of a particular religious group? Do you
So
have any survey, any study?
Yes, Your Lordships, not a survey per se, but this question can be answered in two contexts. Firstly, Your Lordships, if they actually wish to enforce their rights by regardless of their religious belief, then not a single female devotee of Lord Ayyappa has come on to sign their name on the petition. And secondly, Your Lordships, if Your Lordships are aware about the aftermath of the Sabrimala judgment, the Ready to Wait campaign began, where a large section of the female devotees of Lord Ayyappa themselves stated that they are ready to wait and they do not want to encroach upon that court, and they do not want to go to that temple. Yes, okay. Yes, Your Lordships, and the third argument of the petitioners is regarding the fact that there is no public interest as such when matters of religion are concerned. Your Lordships, Article 25 and 26, matters of religion, are extremely personal and intimate rights, Your Lordships. Here,
those who want to approach the court under the guise of locus, there is an apprehension they may be imagining, hypothetically, they may be boycotted from the entire community. Why, how do you answer that? So merely with the fact that they did not approach the court because they are aggrieved with this such kind of practice, there is a possibility that they may be completely renounced, they may be completely thrown out from the particular community. That's also one of the reasons they must be apprehending, and because of that they must not be coming for the court.
Your Lordships, there are two answers in part to this. Firstly, as the council has stated, there are certain other avenues that may be used to do away with such a perceived disability of social pressure and apprehension, which is anonymity of filing and in-camera proceedings. Secondly, Your Lordships, the mere apprehension of social pressure, Your Lordships, disability in matters of religion must be construed in a very specific way. Merely because there is an apprehension of the persons who are members of that denomination from approaching this court due to social pressure to enforce their rights under Article 25 per se, would that allow this court to do away with or infringe on the rights of the denomination itself in Article 26? So this must be read in a harmonious manner to ensure that neither of the rights are deteriorated or destroyed, Your Lordships. And that is the contention of the petitioners, that such applications, such public interest litigations would destroy the rights of the religious denominations under Article 26b, which is the right to manage their own affairs.
But counsel, gender discrimination is a public interest issue, right?
Yes.
Because if there is any discrimination, it becomes a public issue that we have seen in the cases of S.P. Gupta, which was decided in 1981, right? Then even Bandhuva Mukti Morcha, that was in 1984. Then PUCL versus Union, 1997. So this court has very well held that any matter pertaining to the public, okay, even if there is any discrimination to women in this case, will fall under the public interest, in the interest of the citizens of this country.
Yes, Your Lordship. So to answer that, I will rely on the case that Your Lordships has cited of S.P. Gupta versus Union of India. If Your Lordships will look at paragraph 25 of S.P. Gupta versus Union of India, which is on page 222 of the compendium before you, I will read out the court statement. Before we part with this general discussion in regard to locus standi, there is one point we would like to emphasize, and it is that cases may arise where there is undoubtedly public injury by the act or omission of the state or public authority, but such act or omission also causes a specific legal injury to an individual or to a specific class or group of individuals. In such a case, a member of public interest, a public having sufficient interest, can certainly maintain an action challenging the legality of such act or omission. But, and this is an important but, Your Lordships, if the person or specific class or group of persons who are primarily injured as a result of such act or omission do not wish to claim any relief and accept such act or omission willingly and without protest, the member of public who complains of a secondary public injury cannot maintain the action. For the effect of entertaining the action at the instance of such member of the public would be to foist a relief on the person or specific class or group of persons primarily injured, which they do not want. In matters of religion, specifically Sabrimala, if we use as an example, Your Lordships, yes.
Continue.
Okay. The primarily aggrieved persons are the female followers of Lord Ayyappa who are unable to enter in this court. Your Lordships, as we have demonstrated with the Ready to Wait campaign and the unwillingness to file petitions by the members, these members do not wish to claim any right.
Yes.
Thus,
how do we know that? From where are we coming to a conclusion that the women being affected have not at all raised the issue, or maybe they are not ready to take the relief granted by this court?
so, Your Lordships, in this case, it must be important to cite that not a single female follower of Lord Ayyappa has actually come forward to attain. And the mere assertion that there might be some disability, such assertion without the assertion of disability is for the persons who approach the court in PIL to prove. Thus, the mere assertion that there might be some disability is not enough to completely do away with the rights of the denomination under Article 26. then if that contention is accepted, your lordships, then there would be no limit at all to public interest litigation, and this court would be overwhelmed with meddlesome interlopers who just wish to, for the sake of publicity or politics or their own external interest, other interest, approach this court to waste judicial time, harass individuals of the religious denomination, or similarly.
Very well argued, but now I draw your attention to this MC Mehta case, where it was held that constitutional violations will concern all the citizens of this country.
Yes, Your Lordship. Certainly, they do affect all citizens of this country, but they affect all members, all citizens of this country as a secondary matter. Who is primarily the aggrieved person here? In matters of religion, taking Sabrimala as an example, the primary aggrieved person are members of that religion, specifically the female devotees of Lord Ayappa who are unable to enter. Thus, using the ratio cited in SP Gupta itself, it cannot be the contention that simply because it is the contention that secondary interest cannot be allowed to overrule the primary rights of the aggrieved party.
Okay, you continue.
And Your Lordships, to answer a couple of questions that have come up, on the contrary, as my learned co-counsel has just pointed out, the women, female followers of Lord Ayappa have actually filed an affidavit in the matter of Sabrimala stating that they do not actually want to enter the Sabrimala temple, and thus, yes, Your Lordships, that is on record.
We know many such, affidavits are later filed for specific reasons, we know very well. So we don't consider that one affidavit, that will affect all the citizens of this country.
Yes, much obliged, Your Honor. I don't know how to answer that further.
That is a strong view, but very correctly taken by my brother. To guard against filing unnecessary affidavits.
That is the technique being adopted by the petitioners only. They encourage such kind of
Your Lordships, but the mere assumption that there might be certain disability cannot be...
Can those women who have filed those affidavits step into the witness box and can subject themselves to the cross-examination by the other side, if at all, to prove the veracity of those affidavits?
Then Your Lordships would again need to refer the matter back to
How do we test the veracity of the affidavit that those are the same women who have filed the affidavits?
Then Your Lordships, as my learned co-counsel has stated, you would again need to go to the competent civil court and...
That's right. So affidavits cannot be tested at this stage. The Supreme Court cannot test the veracity of that because it's not a fact-finding court. Supreme Court and the higher courts are not a fact-finding court. It has to be subjective. So filing of affidavits is not going to serve the purpose.
My friend, one simple question. Just for sake of understanding, why not this entire issue be referred to the parliament? Let the representatives decide. The locals who have been voted by the representatives, they know the issues, values very well, and let it be discussed in the parliament, and rule or law can be framed in this regard. So what is your submission to that?
Your Lordships, in the matter of referring, may I just take 1 minute of, okay. In matter of referring it to parliament, here again, Your Lordships, the right is not of the public in general. The right of under 26 is of the specific denomination, Your Lordships. So the religious practices are not subject to the majoritarian views of parliament, Your Lordships. And what must be stated is that these are extremely personal rights and extremely specific to only those persons who are members of that denomination, Your Lordships. Only they are competent to determine the matter of religious practices.
All right. We are actually on the separation of powers basically. But anyways, I think
in that case, and I just wanted to ask, how does the court should balance the public sentiment versus the constitutional principles?
Your Lordships, the council does not here in the issue of public interest litigation see any such distinction between the two. Your Lordships, the constitution itself has granted Article 26, Your Lordships. So this right is enshrined not only in the members of that denomination, like it is not a self-claimed right, but the constitution itself that gives this right to the denomination, Your Lordships. And Your Lordships, I would quickly like to conclude by stating that in consideration of all these arguments that have been advanced, this honorable court may be pleased to hold that members who are not persons who are not members of that religious denomination must not be allowed to file public interest litigation questioning the practices of that religious denomination, Your Lordships.
We'll be taking a short break of 5 minutes. Manasvi and Abha will collect questions from the audience. We are requested to reassemble in 5 minutes. Thank you.
so many documents, spreadsheets, videos.
Sukrit, don't go to school tomorrow without seeing this first.
Why? What is it?
Wait. We will open it together.
Okay.
We decided to open it together, and look at that face already. That moment when he saw something new, pure curiosity. And then this came out, a school bag with his name on it. The second
May it please your honorable court. Council would be dealing with two issues, issue number 1 and issue number 2. Issue number 1 is
what is the scope and ambit of right to freedom of religion under Article 25 of the Constitution? And issue number 2 is interplay between Article 25 and 26. Dealing with issue number 1, Your Lordship, India is a pluralist society and a country of religion. Article 25 of the Constitution is a cornerstone to religious freedom in India. There are 5 aspects under Article 25, where firstly, freedom of conscience, that is the faith. Second, freedom to freely practice, profess and propagate religion. Third, universal applicability. Fourth, subject to Part 3. And fifth, subject to public order, health and morality. Your Lordship, freedom of religion operates on 2 levels and covers both the faith and beliefs as well as the practices which are core to the particular religion. This signifies the inner conscience of an individual to shape their relationship with the divine. Your Lordship may kindly refer to compendium page 49, wherein in the case of A.S. Narayana Dikshitulu versus State of Andhra Pradesh, the court has expressly held that the word religion in Article 25 is person to a person having faith and belief in the religion. Therefore, religion is a matter of faith of an individual. There undoubtedly has its basis in the doctrines and beliefs which are regarded by those who profess that religion as conducive to the spiritual well-being. Likewise, Your Lordship, in the case of Shirur Math and Acharya Jagdishwaranand Avduta, the court has held that it is a matter of religious faith and it should not have any restraints upon the free exercise of religion according to the dictates of one's conscience. Your Lordship, moving on to the second limb of the argument, the use of the phrase every person signifies universal applicability of this particular right to freedom of religion irrespective of the citizenship status of the individual. Here, this emphasizes individual freedom of conscience over rigid community dogma. This is a very primary right which is non-discriminatory and is available equally to both men and women as professing any same religion. If both of them are professing the same religion, it is equally applicable to both. Your Lordship, further, this article is not absolute. This right is not absolute as it is subject to Part 3 as well as subject to public order, health and morality. What was thought by the constitution makers was that in conferring the right to freedom of practice, professing and propagating one's religion, it should be in consonance with other fundamental rights as well. Your Lordship,
Then how do you reconcile your argument with Devaru's case, where the court clearly held that Article 25(2)(b) is to be harmonized with Article 26(b)?
Precisely, Your Lordship, Article 25 should be harmonious with Article 26.
So we are just saying that only between 10 and 50 women are not allowed. Otherwise, they are allowed. So it's not an exclusive ban. So what is the problem?
Your Lordship,
even when you go to movie, some movies are only to be seen by adults and others are to be viewed universally. So your so-called argument of universality lies on its face.
Dhurandhar is one of the latest examples.
Yes. Answering to this, Your Lordship, I would beg to differ as the petitioners have contended that the women in the age group of 10 to 50 are violated from entering the temple. It is not a blanket ban, but Your Lordship, the brahmachari nature or the celibate nature.
No, that is another thing, right? But assuming for the sake of argument that there is a reasonable classification doctrine in our constitution, what is so unreasonable? And even if I go by the celibacy argument also, yes, fine. Celibacy is tempered with certain age group of women entering into temple. That is my religious belief. And you know very well that religion does not go by logic. It goes only by the beliefs and doctrines and principles of that particular religion.
Precisely, Your Lordship. On this note, I would like to state if Article 25 gives right to freedom of religion to every individual. On the similar note, it also gives an individual voluntarily not to practice that religion. If we are restricting a woman, it is not adherence to law. If we are allowing women, it is adherence to a law. And if the woman in particular age group, that is 10 to 50, if we take the example of Sabrimala here, then if they voluntarily don't want to enter the temple, then that's their belief they are professing or practicing, which is a core element or principle enshrined under Article 25.
When we talk about the discrimination as such, now if you see, as per the religious practices, there are many temples where even the men are not allowed to enter. I can name you some, like Kumari Amman Temple, Tamil Nadu, Lord Brahma Temple, Pushkar, Attakal Bhagavati Temple, Kerala, Santoshi Mata Temple, Jodhpur, Kamakhya Temple, Assam for certain days, Mata Temple, Muzaffarpur, Lord Brahma Temple, Khajuraho. So these are the practices already being followed for years and years together. So where is that discrimination happening? Because when you talk about religion, it is only about belief, as my brother rightly said. So this is the belief.
Your Lordship, taking into consideration the Sabrimala temple, prior to 1950, women were allowed. There were certain ceremonies which were, for example, first feeding of a child, where women were allowed into the temple. After 1950, a ban was introduced. Therefore, in a garb or under the purview of beliefs or faith, we cannot hide the discrimination.
No. Your argument is very problematic. Say some thieves are caught, others are not. Therefore, what is your logic? Should we allow all thieves to do whatever they want to? Okay, there were few lapses in the observance of this practice, but the lapses do not justify it, that the belief should not be continued, should not be perpetuated, right? It's a religious belief. Okay, we have make amends. There were mistakes. Now we have made amends. What is the problem?
In order to, as your lordships have said, the amendments have been conducted. The basic on which religion is based are the doctrines or beliefs which are followed from age-old traditions or age-old since time immemorial. So, considering amendments after a certain period does not qualify it as proper.
Okay, great. Please proceed.
Your Lordship, also the petitioners have, relying on the example of Sabrimala, has stated that there are no affidavits been filed in the court regarding who the women were affected or not. But Your Lordship, as stated by me earlier, if the women voluntarily don't want to enter into the temple, it's their practice or profess towards the particular belief. Also, I would like to quote an example of the case of Shani Shingrampur, wherein the court has uplifted the ban of women entry into a temple. But women voluntarily are not entering into the temple. It's their voluntary right, which is protected under the Constitution itself. Your Lordship, if you are satisfied, Council 6 proceed. Yes. As this right under Article 25 is not absolute, it is subject to Part 3 and subject to public order, health and morality. Therefore, it is well inferred that Article 25 grants any person the right to entail their belief, but it must be in regard to other fundamental rights which are enshrined under Part 3. Your Lordship, dealing with Clause 2 of Article 25, this protects laws which existed at the time of adoption of the Constitution and the power of the state to enact laws in future, dealing with two categories. Firstly, which consists of laws regulating or restricting financial, political or other secular activities which may be associated with religious practice. And secondly, the laws consist of providing social welfare and reform. Your Lordship, the purpose of clause 2 here is to protect the ability of the state to protect and enact the laws which are clarificatory in nature and stand recognized under clause 1 itself.
Counsel,
Yes, Your Lordship.
in that context, I would like to ask you that religious institutions like temple, mosque or churches, they are religious institutions. They cannot be per se termed as a secular or public places. So how you are going to justify that equality before law means equality before religion or religious deity?
Your Lordship, equality in the sense is depending upon the belief of any person. The person should be allowed in various institutions, religious institutions, the person who is professing any religion for that matter, may it be Hinduism, Muslim, Christianity, any religion. Equality in the sense it's not levied by the state itself, it is the beliefs of an individual which are to be protected. Council seeks permission to proceed with the second issue. Second issue is regarding the interplay between the rights of persons under Article 25 and rights of religious denomination under Article 26. As is pointed out by the petitioners itself, Article 26 guarantees every religious denomination 4 rights, which are to establish and maintain institutions for religious or charitable purpose, manage its own affairs in the matter of religion, to acquire movable and immovable property, and fourthly, to administer such property in accordance with law. Your Lordship, in order to classify or qualify as a religious denomination under Article 26, a triple test was given under in the case of SP Mittal versus Union of India, wherein these 3 conditions were a collection of individuals with a common faith, a common organization, and a distinctive name. These 3 conditions were to be satisfied in order to fulfill it as a religious denomination. My contentions over here are, Your Lordship, Article 25 deals with individual rights, Article 26 deals with collective rights of religious denominations. Religious denomination is a collective group of individuals, so the right under Article 26 flows from Article 25 itself. So there is they are interconnected and cannot be read in isolation.
My dear counsel, let me attract your attention toward denomination. Right, it comes from the Irish Constitution. Right.
Yes.
We were inspired by the Irish Constitution. Now, in Irish Constitution, when the word denomination is used, it is used in a Christian sense. Would you use it in similar sense under Indian Constitution, number 1? And number 2, you should also know that now Irish Constitution has been amended, and to the best of my memory, the word denomination has been either deleted or it has been properly defined. So, how do you, you know, in Hinduism or in Hindu religion, you don't have strict compartmentalized denominations, right? So your logic that Ayyappans are not a denomination, and when you use a particular test, the triple test, even if I accept your argument for a second, it's a mixed question of law and fact, which cannot be argued before the Supreme Court, particularly under writ jurisdiction. It should be argued before a trial court, a court of facts, right, which is lower courts. So, on both points, what are you aware of Irish constitutional developments? Number 1, have you studied the notion of denomination? And number 2, what about trying the matter before the lower court rather than Supreme Court?
Your Lordship, Council would yearly firstly state that even if this religious denomination, which is borrowed from Irish Constitution, where it is adopted in the sense where, according to the society India has a pluralist society. There are various of religions in our country. Accordingly, the definition in our term changes apart from the Irish constitution. Even if it is used in a distinctive sense in Irish constitution, in India we as a collective different religions are considered. It is a religious denomination should be considered in consonance with Article 25 itself, as individual rights are expressly protected under Article 25. Council 6 proceed. Obliged. If your lordship, Article 26 is immune and isolated to Part 3 itself, it would violate the basic fundamental rights which are enshrined under Part 3. Even if there is no such phrase mentioned in Article 26 that it is subject to Part 3 of the Constitution, or for that matter Article 25 in itself, but it cannot override or stand isolated from Article 25, as it is they are housed in Part 3 of the Constitution itself.
Can I just raise a hypothetical question, an imaginary question? If at all your diet or appetite is completely vegetarian, and some guest comes to your house and they demand for a non-vegetarian, which is absolutely not allowed in your house, what is going to be your approach to it? And if at all, considering the protocol of their house that each and every member is completely vegetarian and a guest is demanding non-vegetarian, are you going to accede to his request, or you're going to deny it? Because I am trying to correlate with the same principle insofar as Sabrimala is concerned. Sabrimala is something which happens to be a house of Ayyappa.
Yes.
The protocol is this, that whatever he was a celibate for XYZ reasons, he himself had renounced this particular principle. Those the ladies of the reproductive age, he had basically renounced and he went to the jungle. That's what something was a mythological story.
Yes.
So once you are going to his house, and if you are trying to seek blessings from him, is it possible in any kind of eventuality that you are going to aggrieve the person by not following the protocol after going to his particular house? I mean, I'm trying to correlate if at all some visitors happen to come to your house and demand for non-vegetarian food, and which is not allowed in your house. How is going to be your stand?
Firstly, to answer the
sorry, I'm just raising a very hypothetical question, but
answer the hypothetical question, your lordship. It is a very subjective term with respect to vegetarian, non-vegetarian. So if a guest arrives, I would rather insist that we are vegetarians and they would eat whatever it is prepared. Or second option is I would order online. Taking Can I proceed? Dealing with the Sabrimala question with reference to this hypothetical question, the brahmachari nature of the deity is such that women are not allowed. But your lordship, the Shastras that gives the rules for brahmachari also gives how a brahmachari needs to conduct in presence of women. In our smritis, it has been expressly mentioned under the Chanakya Niti as well that a woman is considered as a mother. So there is no question as to break the celibacy of any god or any deity if a woman is considered as a mother.
See, Mr. Consul, the opening lines of section 24 read, subject to public order, morality, health, and to the other provisions of this part. Means other provisions of this part are not laid in isolation. What may be the reason that both are showing connectivity in that? Simultaneously, why they have been mentioned instead of making reference of only part 3? Are you following me?
Yes, your lordship.
You may answer it as to why. Because part 3 is not to be considered only. If a reading is given, close reading to section itself, subject to public order, morality and health, and means these 3 factors to be read along with part 3. What may be the reason behind when absolutely that right is conferred upon in part 3 itself?
If your lordship, it is the very opening statement is subject to public health, order and morality. it is regarding the social aspect which is governed in the society. This very issue will be dealt with by my co-counsel in detail while dealing with morality and constitutional morality. Your Lordship, to sum up, Indian secularism is not is intervenist and not separationist. Court gives the test to circumscribe and interprets the articles with harmoniously in order not to nullify any of the article or suppress any of the article.
May it please, Your Lordships. Your Lordship, this is counsel number 2 on behalf of the respondents. I will be dealing with issue 3 and issue 5. Am I audible? Yeah. I will be dealing with issue 3 and issue 5 beforehand. But Your Lordship, Justice Desai raised a hypothetical query, if I may answer. Your Lordship, the issue 3 talks about whether the rights of religious denomination under Article 26 of Constitution of India are subject to other provision of Part 3 of the Constitution of India apart from public order, health and morality, which are the opening words of the Article 26. My lords, the hypothetical question which was raised, in my defense, a right of a religious denomination incurred under Article 26 by managing their own affairs. They can do anything but cannot go against the Part 3 is my basic core preliminary submission before this honorable court. And I will be going with, first I will be addressing the textual interpretation of 26, then the Devaru harmonious construction, as well as Article 13 line of action on this aspect with Shirurmat reliance on the foundation. My lords, if we read the bare text of Article 26, which says subject to public order, morality, health, every religious denomination or any section thereof shall have the right A. to establish and maintain institution for religious and charitable purpose, B. to manage its own affair in matter of religion. My lords, take a key note on this. C. to own and acquire movable and immovable property, and D. to administer such property in accordance with law. Now, my lords, I will like to bring the honorable court's attention on to literal inference of this textual nature. My lords, first inference is that the Article 26 is not an absolute right. It has been limited by morality, public morality, public order and public health. My lords, this constitute an expression of limitation. And second, if my lords may read clause D, explicitly subjects property administration to in accordance with law. If even property administration is subject to law, my lords, matter of religion under clause B cannot be completely immune from part 3. The structure...
No, but you can't just... If you start drawing implications like this, then you will rewrite the entire constitution, right?
My lords,
you will then upset the balance.
My lords,
of the
I will
structure.
very well satisfy honorable...
How do you... I mean, it's preposterous to collapse one clause into other by implication.
My lords, much obliged. My lords, I will be answering this with a respect of Maneka Gandhi versus Union of India.
So Maneka Gandhi does not tell you to imply.
My lords, but what I wanted to prove is that the fundamental rights conferred by Part 3 are not distinct and mutually exclusive rights. Each freedom has different dimension, and merely because of the limits of the interference with one freedom are satisfied, the law is not freed from necessity to meet the challenge of another guaranteed freedom. It was raised by Justice Jain, sir, while my review petition.
No, I was questioning the other side. That does not mean I have formed my view on this. You can't use my views to justify your argument.
No, my lords, my view is that fundamental rights are not mutually exclusive rights or distinct right. My lords, if I am having a freedom under certain right of Part 3, that doesn't mean I can eradicate other freedom. That is my contention before this honorable court.
But we are not eradicating. We are merely saying that between 10 to 50, please don't come.
My lords?
As much as when in a Jain temple, there is a board that please, if you are non-vegetarian, please don't come. What is the problem? It's very simple.
My lords, here religious denomination can decide their practices as inferred by Article 26b, managing their own practices. But what my contention is that practice cannot go against the Part 3 of the Constitution at any sense. Because, my lords, if it does, then it will create a very big flood. Because, my lords, what happened will that such practices like sati, child marriage, which has been restricted and considered as unconstitutional, were all consideration of the religious denomination itself. And particularly, my lords, when we refer to a religious denomination having their practice, they are referring to customs and uses. Now, my lords, custom and uses are a part of Article 13, 3A. They are considered as law. And secondly, my lords, and if we read Article 13(1), it clearly states that anything defined as law cannot be inconsistent with Part 3, otherwise it will be considered as void. So any custom inconsistent with Part 3 cannot be considered. So does the religious denomination rights under Article 26.
Yeah, Mr. Counsel, in some of the cases, this court has clearly held that the constitutional morality includes the religious freedom. Okay, that means Articles 25, 26 are constitutional values, and this we have settled in cases like S.R. Bommai, 1994, Bijoy Emmanuel, 1987, Sardar Tahir Saifuddin, 1962. This is what this court has held. So where is the issue?
My lords, now as I mentioned that Article 26 is not an absolute, it has been restricted by three aspects, which my lords highlighted. Morality. Now, why does morality will be constitutional morality? It will be highlighted by my co-counsel. But while what is morality? Morality in Hindi terms is called as sadacharya, which is meaning as a good conduct. Now, why that good conduct should be constitutional? Otherwise, my lords, there is no. And if we mention what is constitutional morality, it does not only sustain to Part 3. Constitutional morality also goes on the preamble, the text of preamble, and other values of the Constitution which has been mentioned by the Constitution itself. And now what is good conduct, which is called as morality? That good conduct needs to be constitutional morality, because if we refer to otherwise, it can be majoritarian morality or it can be plural, whatever it is. That cannot be accepted by this honorable court, because there is an existence of Part 3 as well as constitutional principle before us. And more particularly, my lords, with answering that view as referred to the judgments, even in Devaru, the court considered the harmonious construction aspect, which is very essential. My lords may take a key note that in Devaru, the court considered it was the same temple issue, that some certain section was not permitted to go an entry of the temple. The court considered that Article 25(2)(b), which is the state's legislature power to not stop any sections of Hindus from entrance of the temple. This was prevailed, and they mentioned that the key wordings are, if the denominational rights are such that to give effect to them would substantially reduce the right conferred by Article 25(2)(b), then of course in our conclusion that Article 25(2)(b) prevails as against Article 26(b). The denominational right must vanish. The principle of Devaru applies with equal force to conflicts between Article 26 as well as any article such as 14, 15, 17 and 21. If denominational right cannot substantially reduce the right under Article 25(2)(b), they certainly cannot destroy fundamental rights under Article 14, 15, 17 and 21. Otherwise, there is no purpose of Part 3 of the Constitution per se.
No, Counsel, Devaru involved what?
My lords, Devaru.
Why Devaru arose? Who were the affected parties in Devaru? The Saraswat Brahmins, right?
Correct.
They wanted to restrict the entry of public during certain most important ceremonies.
Correct.
Whether court granted them this right or not. Court granted this right to Saraswat Brahmins, as much as court must grant this right to Ayyappans, that during certain age, because of XYZ reasons which are purely religious, one should not be allowed. So in fact, Devaru doesn't help you at all. Right? It goes against you.
My lords, but aspect was that Article 25 2b shall prevail as against Article 26b. The denominational right must vanish. This was the core contention.
Must vanish. Where is the vanishment? We are not saying that all women are banned. Right would vanish when in entirety all the women from all age groups are banned. Is this the case?
My lords,
and it doesn't say also.
Where does it say
The
it will
judgment
have an
doesn't say
overriding
like
effect on 2026 2b?
my lords, that is what the Devaru contention
No,
of
no,
Devaru
no.
was.
But
It said
is
that
there any
25
issue which was framed by the Supreme Court thus far that 25 2b will have an overriding effect insofar as 26 is concerned, wherein the religious denomination will be completely circumvented by 25 2b? It's not a declaration though so far. So how are you going to justify that?
My lords, my justification
26 2b stands at its own place. It's a standalone kind of a provision. 25 2b is a standalone kind of provision. If there is a conflict with each other, then which provision is going to prevail? That's something which is not being provided anywhere in the Constitution. So how are you drawing that analysis?
My lords, I beg to differ on the stand-alone aspect because as I mentioned, Maneka Gandhi, R.C. Cooper as well as even in case Puttaswamy it was held that the part 3 is an integrated whole. You cannot dissect part 3. If you are having, as I mentioned in Maneka Gandhi, if I am having certain right...
That's a good answer. That's a good answer. I'm impressed. Yes.
Well, if I may recall, I satisfied Honorable Court on Maneka Gandhi stand as well as R.C. Cooper stand and K.S. Puttaswamy. In K.S. Puttaswamy also this Honorable Court held that when I am having my right to privacy under Article 21, that doesn't mean I can go violate Article 14 and Article 19 per se. My lords, are satisfied with that? My lords, if I may highlight now the aspect of the danger of absolute immunity. It will be a slippery slope if the contention of my review petitioners been considered by this honorable court, because that if the interpretation of my review petitioner is accepted, any denomination could declare any practice essential and claim immunity from Article 14, 15, 17 and 21. And my lords, acknowledge the triple test. It is very easy to create a religious denomination. I myself can create a religious denomination because there are only 3 essentiality which needs to be adhered. First essentiality being it should be a collective, it should be a collection of people. Let's see, my lords, if I take an example of a hypothetical nature, I am instituting a religious denomination by collection of people having a common faith and having a distinctive name. Now, I being a religious denomination, I cannot create a practice such as you have to kill an animal before practicing this worship or before going to the temple.
Counsel, you are not reading Article 26 properly. Can you read denomination? There are certain other words after denomination.
My lords,
can you read the part dealing with denomination? Please read.
Yes, my lord.
The language of the article.
Ma'am, Article 26 talks
religious
about
denomination or any sections thereof.
Obliged, my lords.
So even intra-denominational freedom is also protected.
Lordship, that creates their case more worse because if such aspects are being considered, if certain practices which are unconstitutional, like the aspect of sati, as which was just a minute, Lordships. Aspect of sati, as well as Muslim denomination, like excluding women from entrance of mosque, as well as Parsi denominational excluding women married to non-Parsis from entrance of fire temples, and as well as Daudi Bora's community justifying female genital mutilation. This aspect cannot be considered as constitutional at any part.
You are confusing completely. There is total confusion in your mind. You can't compare the religious practices of different religions with one another. That's not how Supreme Court adjudicates on freedom of religion.
Lordship,
then you will start arguing that one religion is better than the other religion. You know, you remember a case was filed in Bombay High Court long ago, if you read Sirvai, and the argument was that Quran should be declared unconstitutional. You know, and the lawyer was, I think, imposed an enormous cost on the lawyer.
Lordship, my
it's a preposterous thing to challenge the validity of a religious scripture. How can you do that? Yeah, and these are pending matters. So you can't. I mean, are you serious to compare sati with what is happening in Sabri?
Lordship, the only inference which I wanted to highlight.
Inference must be realistic.
I obliged and apologize for the same, but the inference which I wanted to highlight is that a religious denomination cannot go against the part 3 by just saying that this practice is essential for them. Because otherwise, why is there a part 3 at the first place? That aspect comes in. And my lords may refer that in Adi Saiva Saivicharyal Nala Sangam versus Government of Tamil Nadu, they mention the constitutional legitimacy naturally must supersede all religious beliefs or practices. So, my lords, even if you are practicing certain religion or you are a religious denomination having certain practices, it cannot supersede constitutional legitimacy. That is whole and sole contention of my argument. My lords may appreciate. And even, my lords, my learned friend referred to the Constituent Assembly intent. My lords, the Constituent Assembly intent, it was Article 20, it was Article 19. On 7th December 1948, while moving to insert the word subject to public order, morality and health in Article 20, which is now Article 26, Dr. Baba Sahib Ambedkar stated that it was just an omission. Honorable members will see that these words also govern Article 19. As matter of fact, this should also have governed Article 20. Because it is not the purpose to give absolute right in this matter relating to religion.
No, that is the very reason why we should be wary of using Constituent Assembly debates. Parties can give their spin on the debates, right? And that is why courts are very nervous in using Constituent Assembly debate as primary source of interpretation. They are secondary sources.
Yes, just they refer
so they can't help you anyway.
My lords, further they also stated that the state may reserve to itself the right to regulate all these institutions and their affairs whenever public order, morality or health require it. This is Constitutional Assembly Debate Volume 7, Part Para 978. The framer explicitly stated that it was not the purpose to give absolute rights in matters of religion. The review petitioner claimed that the Article 26 confers absolute immunity from Part 3. It is directly contrary to the framer's intent, was my sole contention here. Lordship, in conclusion of this particular issue, may I conclude that the correct...
Counsel, I have just one question. You continuously argue that freedom mentioned in this fundamental right chapters or fundamental right part has to be read integrated. Does it mean that every sort of freedom has to be read conjointly?
No.
And whether this is a fit case for your argument or in your argument?
Well, with respect to that, I will be answering that aspect while relating that if I am having my any freedom which is mentioned in Fundamental Rights Part 3, I cannot eradicate other freedom. That is what contention, and that is what held in Maneka Gandhi, which I highlighted before this honorable court. That while if you are having certain right in fundamental rights, if you are having that freedom, you cannot eradicate the other freedom. That is the whole and sole contention.
All right.
While concluding issue 3, my lords, the correct constitutional position in that Article 26, whether it is subject to Part 3 or not, it will be that indirectly through harmonious construction as established in multiple judgment, Devaru, Shirurmat, that it does, and operationally through Article 13, which voids custom inconsistent with Part 3, and structurally through integrated nature of Part 3 as I mentioned, established by the Maneka Gandhi as well as R.C. Cooper. My lords, I will be moving on issue 5 if my lords are satisfied. My lords, issue, may I? Yes, obliged. Your lordship, issue 5 in my hand is what is the scope and extent of judicial review with regard to religious practice as referred in Article 25 of the Constitution of India. Now we are talking about Article 25, not Article 26. Article 25, it is subject to Part 3. My lords are satisfied with that. My lords, the respondent in this issue submit that the judicial review of religious practice under Article 25 is not only permissible but constitutionally mandated when such practices infringe upon the other fundamental rights, violates constitutional morality or perpetuate discrimination. The scope of judicial review extends to determining whether a particular practice is genuinely religious or not. then whether this practice is essential or integral, because the test of essentiality and integralness is been established by this honorable court. And third, whether it violates part 3 or not, and whether it is consistent with constitutional morality, and whether it is a mere superstition assertion. All this aspect comes under judicial review, which the honorable court has the power. My lords, the review petitioner mentioned that there cannot be a court intervention in Article 25. My lords, with that argument, I will be relying on having judicial review is not an intervention. It is a power of this honorable court or a constitutional duty of honorable court. My lords, there is a very clear distinction. My lords, the legislature, while making the law, they are not intervening in the society. The executive, while following the administration, they are not intervening with the individual rights. So, my lords, the judiciary, while having judicial review, are not interfering with the religious aspect or any other review in front of this honorable bench. But they are just doing the constitutional duty which has been mentioned by Article 32 before this honorable court.
Mr. Counsel, that insofar as your earlier arguments, you have stated that your fundamental right should not violate others' fundamental rights also. So by entering that particular woman during that stage into that institution or into that place of worship is not violating the others' right of worship?
My lords, with Sabrimala, keeping in mind in Sabrimala, which was even this contention was considered by Justice Chandrachud as well as Justice Nariman, they clearly mentioned that having the right of a woman entering in that temple is being instituted by Article 25 2b, that you cannot restrict certain section of Hindus. That will be prevail over certain denomination rights, as in the Sabrimala case, it was not established that particular the Ayyappans are a religious denomination or not. And even as mentioned, that this practice is not at all considered in other 1,000 temples of Lord Ayyappa. That was only for that particular temple, and that is why the nature of that deity and the religious denomination was in dispute, which was considered by Justice Chandrachud as well as Justice Nariman in their majority opinion 4:1.
But good that you talk about Nariman and Chandrachud. Don't you think that Nariman and Chandrachud differ on the issue of constitutional morality? Nariman clearly negating the application of constitutional morality. In fact, he assumes that, okay, it's a religious practice. Okay, he declares it unconstitutional on different grounds. So therefore, when I think you are by and large using constitutional morality. So do you know the difference of opinion between the two judges? Have you read?
Just the last line.
Yeah, please.
Your Lordship, just repeat the last line. I didn't heard the last line.
I'm saying, are you aware of the deep divergence among the majority judges in themselves about the scope of constitutional morality? It's a vague animal, right?
Lordship,
in fact, Nariman has written a lot in his judgment. And he tends to agree with Indu Malhotra J.
I certainly affirm with the Honorable Justice Jain's opinion, but Your Lordship, that morality aspect will be dealt by her, and there it will be the argument, the gambit of the argument is why the morality is constitutional morality. And while referring to Justice Rohinton Nariman as well as Justice Chandrachud, while they mentioned the case laws of the other countries also, all those aspects were considered while determining the morality, and particularly in India, the morality shall be referred as constitutional, as my Lord Co-Counsel will prevail on that. My lords, even I will just sum up very quickly that Justice Indu Malhotra's opinion, Justice Indu Malhotra's dissent judgment, there it was highlighted that the factual essentiality, which is like existence of
the court should not interfere into the religious faith. The court should not interfere into the religious faith and the rationality of religions and the practices. So, in our constitution, if Article 14 has to supersede all the time the other articles like Article 26, is the Article 26 so hollow, so made in the constitution that every time Article 14 has to supersede?
Lords, with that aspect, in my submission, the submission on behalf of respondent, we partially agree with the contention that to determine the essentiality and genuineness of that fact, the mixed question of fact, that is to be determined by civil court, but the greater constitutional questions, that is to be determined by
Why I
constitutional
mentioned,
court.
because post the judgment, you know, in 2018, there were many, I would say, women and other associations who came on the streets and they were demonstrating against the judgment itself.
My lords, obliged. But my lords, while even restricting civil court jurisdiction to determine the mixed question of fact, my lords, the civil court cannot exceed or cannot declare a custom. It cannot declare a practice as a custom under Article 13. That will be dealt by constitutional court. That is why my reliance is that the deep question, whether the essentiality of a practice and whether that it is in violation with the part 3, that is to be dealt by the constitutional court, which has been considered by this honorable court in plethora of Supreme Court judgments. And more particularly, the factual essentiality exists, which my even learned friend affirmed, that factual essentiality, existence of a custom, textual interpretation of that custom, that is to be determined by the civil court. And I am in agreeing with that contention.
So long as courts of facts are concerned to determine if matters or subjects are referred. Now the citations or case laws which are decided by High Court and Supreme Court, whether they can be relied upon by a trial court, again the same issue would be there, as if trial court is following those principles and deciding the entire subject conclusively, then whether it would amount to dominate the jurisdiction of High Court and Supreme Court if that trial court is going to decide such issue. Are you following?
Yeah, my lords, I am following. That is why I mentioned the essentiality of the same shall be determined by the constitutional court, the Supreme Court in this case. But to determine whether that facts genuinely exist or not, that is to be decided by the civil court. And whether there are to dispute, there are as even in Tilket Maharaj versus state of Rajasthan, it was held that a religious denomination having multiple voice, then and there a religious denomination itself cannot decide what is essential or what is not. That is to be decided by the court. And particularly, my lords, if I just sum up what was mentioned in Shirur Math, it mentioned that till the scope of judicial review in Article 26 and an essential religious practice, that is to be determined primarily by the religion tenets, but not exclusively or solely. This was not mentioned, but they mentioned it was primarily to be determined by the religious institution, not exclusively or solely. The court has the right to determine the same. That was my core contention. And with respect to the submission that certain prospects of factual nature shall be dealt by the civil court.
If in this particular fashion the judicial review is being allowed, are you not considering or imagining a position that this will amount to tinkering with the religious sentiments of the people? It will hurt the religious sentiments of people.
Well, in my humble submission, I will like to...
Maybe they are in minority, but I can say that the majority is trying to overpower or trying to dominate the religious sentiments of the minority.
My lords, I will...
Such practices are being practiced or propagated since time immemorial. A very fundamental question.
My lords, much obliged for the question raised before me. My lords, even this honorable court raised that the Supreme Court is not a court of facts, it is court of law. So I would like to state, my lords, the issue of facts, whether that facts exist or not, whether fact is genuine or not, whether there is, as even considered in many judgments, that whether this particular practice is genuinely there or is essential. Essentiality is determined by constitutional court, but the factual matrix as considered by Justice Indu Malhotra is to be determined by the civil court, and that won't hinder any of the individual rights, because it will give a record in front of this honorable court in the furtherance of the proceedings.
Learned Counsel, I have one important question to ask. Now, when we talk about many of the laws which have been framed considering the women, whether it is maternity benefit, whether it is DV Act, whether it is Section 69 of BNSS, etc., etc., and also the recent reservation for them in the parliament. So where is this Article 14? Then don't you think this would have been the violation of Article 14 in this case, in these cases, in these laws? So what if any such rule is being made, or maybe Article 26, has been invoked here for the, the personal practice in the, in the religion or for a particular temple? So what is the issue here?
My lords, particularly relating to those examples or those circumstances, I'm not certainly aware of the same, but I am aware of the fact that, my lords, every fundamental right is not absolute. It is been limited by certain aspect. For example, Article 21 is limited by procedure established by law. Article 41, the discrimination is also limited by the state acts. My lords, in my submission for this issue, while it will be an individual circumstantial issue while realizing whether that particular act violates constitution or not, that will be decided by this honorable court. But whether it should not at all. No law can violate the part 3 which has been considered by this honorable court, and particularly the religious practice cannot also violate a part 3 while a religious denomination accessing them under Article 26 is my core submission. If my lords are satisfied, I will be concluding. Much obliged. It was a pleasure in front of arguing 9 judges.
Hello. Yes. May it please your lordships, I appear as the learned counsel for the respondent, and I'll be addressing issue number 4 and issue number 6. At the outset, addressing the 6th issue, that is, what is the meaning of expression sections of Hindus occurring in Article 25(2)(b) and of the Constitution of India. So at the very outset, the petitioner has confined the expression sections of Hindus. The 3 grounds on which sections of Hindus were interpreted and argued was that first, Hindu is broad. They agreed to the concept that the word Hindu is broad but functionally caste oriented. Second, the Constituent Assembly debates that give the legislative intent being caste centric. And the third, that is rejection of K.T. Shah's amendment. So based on the petitioner's argument, it is a very primary contention that the interpretation of the word sections of Hindus is to be done in more broad progressive manner, which I'll be doing in a threefold manner. First, the Constituent Assembly debates. Second, the purposive constituent, the phrase sections of Hindus, the interpretation of the phrase sections of Hindus, and third, the transformative nature of the phrase section of Hindus. To begin with the Constituent Assembly debates, there are total 3 Constituent Assembly debates or dialogues that were held regarding the phrase sections of Hindus. I would be citing one right now and 2 of them in the later part, the transformative nature of 25(2)(b) while addressing the same. Now, if we come to the compendium page number 12, if my lords could refer to compendium page number 12. We have the Constituent Assembly debates the proposal of amendment by G. Durgabai. So if we read literally, that is, sir, that in subclause B of clause 2 of article 19, for the words any class or section, the words all classes and sections be substituted. Along with not just the literal interpretation, we also need to understand the intent that was presented behind it. That is, sir, the object of my amendment is to enlarge the scope of the clause it stands. The clause as it stands read does as follows. So if we understand the interpretation of the word any and all, so when we interpret the word any, it can be one, some or all. But when the word all is to be interpreted, it is very necessary that the shift to all removes any possible ambiguity and makes the inclusivity complete and explicit. So the intention that was presented in the Constituent Assembly debates regarding giving a broader, enlarged interpretation to the phrase sections of Hindus is to be considered. My lords, here the point is now whether the broad interpretation is to be taken only in the case to include all castes and not gender. So for that we can again refer to the definition of Hindu and the interpretation of the phrase sections of Hindus. For the same, under the Kerala Hindu Places of Public Worship Authorizations of Entry Act, as well as there are numerous legislations like the Hindu Succession Act, where while discussing the petitioner's argument, we came to the definition of interpreting the word Hindu. So it is mentioned that Hindu is defined to include persons professing the Buddhist, Sikh or Jain religions. Now I would draw my lord's attention more over to the word persons than over to Buddhists, Sikhs and Jains. That is, when the use of word person is done, person can be understood in multiple settled ways. That is, citizens, non-citizens, gender neutral, as well as women, men, that is the gender neutral concept. Therefore, the word person in the word definition of Hindu should be understood in the broadest possible sense, that the legislative intent was not just to carve the caste discrimination, but also creative interpretation can be given to address the concerns of gender discrimination or any other consideration that is rising with progress of time. And the second...
Now, Counsel,
Yes, my lord.
when you say that person must be interpreted widely, right?
Yes, my lord.
Again, this is your opinion, right? Because when we interpret the Constitution, it is subject to context. So there was a case known as Parsons case, a Canadian case, wherein court held that in the context, the word person would not include women, right? And later on the law was amended, and of course women were included. So therefore, when you are interpreting the word person in the religious context, can you neglect, can you overlook the religious conceptions, religious beliefs, religious doctrines?
Okay. My lord, I am not just interpreting persons here, as well as now I will be explaining how sections should be interpreted. So a broad interpretation to the word person in the definition of Hindu is for the sake to show that if there was a particular legislative intent, that is, we find in Article 17 regarding caste discrimination, the same would have been put forth in the article to present the legislative intent by our founding fathers. But since the scope for broader interpretation is given, it is essential to understand that there is some intent or legislative intent of the founding fathers that they are putting forth to give a scope for the creative and progressive interpretation.
But here, there is no question of, as what I could make out from your argument, there is no question of gender discrimination here. There is no gender discrimination insofar as this particular case is concerned. It's just men and women both are allowed, save and except the fact that women of a particular age group is not allowed.
Yes.
I would say it would have been a case of gender discrimination that per se women of all the ages are not allowed. Then it would have been a case of gender discrimination. Then your argument insofar as legislative intent and what is Hindus is something which would have been right. But here is the case that there is a class of people who have been exempted insofar as entrance in the shrine. Then I don't think this is a case of gender discrimination.
Yes, my lord.
To add it further, like for instance, there is a temple in Kerala only, and its name is Attakul Bhagavati Temple. And in this temple, only women can go. Nobody can go, no men can go, no men can enter. So, do you think if this code goes on considering these religious aspects and practices, so it will be a never-ending process. These are the beliefs. When you believe in a religion, when you believe in God, so obviously all the procedures also you will believe. So accordingly, if this belief is there for this particular temple, or maybe for that matter for the other temples where even men are not allowed, for instance, so don't you think it will be violation of Article 26 for certain sections of the society?
Yes, so my lords, I'll be addressing both of your queries. The very first thing that Yes, so my lords, as I mentioned that while interpreting person, I did not just mention men, women, I also mentioned non-citizen, citizen. So very first thing is that obviously it is to be considered that it is not just meant to gender discrimination, and it is a broad issue of how the word person should be construed. But now coming to the specific part, that is it is not to be considered as gender discrimination. My lords, it is a very valid point that they are just obstructing the age, women from the age 10 to 50 while they are allowing rest. But it is very essential to understand that on what basis is this discrimination done. If a discrimination is done on a physiological characteristic that is peculiar to a particular gender, it directly goes against the core values of the constitution. And let it be one of the point by the petitioner was that if such homogeneity, this will bring homogeneity in the temples and the diversity of temples will end. But my lords, for the sake of preserving diversity, are we going to go against the constitutional values that are embedded in the preamble, that are the core point? I would also address them in the concern of constitutional morality. But why women from 10 to 50 still amount to gender discrimination is because, not because just above 50 and below 10 are allowed, but this is associated with a physiological characteristic which is peculiar to a particular gender. If my lords are satisfied, I would move to the next argument.
Yes, continue please.
Yes. So my second interpretation is the word sections. So secondly, the definition of the my lords, there can be. Yes, there should be reasonableness for the distinction which is absent and which is on basis of physiological character and peculiar to a particular gender. Yes, so it is discrimination under 15. Now interpreting the word section, that is equally wide, section or class, it is not confined to caste alone but expressly extends to every form of grouping. That is, the wordings in the definition of section are given division, subdivision, sect, denomination, and at the end explicit mention of the word whatsoever is given. So now the term whatsoever removes any scope for limitation to interpret what can constitute a section. That is, it indicates that every possible section within the Hindu fold is to be included when we interpret the phrase sections of Hindus. Now again, to understand it in totality, that is, it is not section of Hindu or sections of Hindu, it is sections of Hindus. So essentially there is an intent to give a broad and progressive approach to the phrase. Now coming to the next contention, that is, we also have catena of judgments. One of them is S. Veerabhadran Chettyar versus E.V. Ramaswamy Naikar, that expressly court has added this statement that court expressly rejected a restricted interpretation of the words general that are in general import. So it held that where legislature uses wide language such as any class of persons, it is impermissible to read in artificial limitations. Now,
Miss Counsel,
yes.
so far as Article 25(2)(b) is concerned, you know, it gives all the powers and liberties to the state to make the relevant rules, regulations, laws, so far as any religious reform is concerned. So why not, a law may be framed under this article by the concerned state in the interest of the affected people?
My lords, we interpreted Devaro in that sense that under 25(2)(b), if such a law is made and it violates the freedom that is granted under Article 26, we need to interpret it harmoniously. A answer to that, I think, which should be appropriate, is that in the case of Devaru, it was stated that okay, you can obstruct people but for some religious ceremonies that are peculiar to the particular denomination, but it is also equally said that the entire right to worship cannot be denied, my lords. And in this case, if we concern it to Sabrimala, you are completely taking away the right of the woman between age 10 to 50 to worship. If some particular
Council,
restriction...
there is a big confusion. We are not taking right to worship. We are just saying that don't worship in a particular temple, and Constitution does not anywhere say that women have fundamental right to worship in all temples, as much as men have fundamental right to worship in all temples. Right? There are certain temples where men cannot enter. There are certain temples where women cannot enter.
My lords, but again, coming back to my
So
point...
it's a very far-fetched argument.
Yes, the distinction is to be examined on what basis the distinction is done.
If you are saying, I'm sorry.
See, if I may ask you, Mr. Consul, Article 25, sub-article 2 reads, it reads that state can make a law. Means it is now competence of the state for legislation. Now whether that is subject to only social welfare and reform intent as contemplated in B, or can it go beyond that? What is your opinion, or how you may argue on that? Are you following my question?
Yes, my lord.
How you may answer?
Okay. My lord, I am about to come to the point that Article 25(2)(b), how it is transformative in nature or with the intention of transform, and if my lords permit, can I next? Yes. So how it is based on a transformative character. If my lords permit, I would address it in my upcoming submissions. Yes. Now I would come to two Constituent Assembly debates that I said that I would mention later. That was one by K.M. Munshi. Yes. So that was one by K.M. Munshi, that the phrase throwing open Hindu religious institutions of a public character to any class or section of Hindu was introduced in such a way that there is a possibility that it can go against the religious freedom that is granted under 26. But in the same assembly debate, it was stated that it would not violate religious freedom and would instead fall within the permissible scope with the intention of social reform. That is also a part of 25(2)(b), the first phrase before throwing open sections for Hindus, throwing open temples for sections of Hindus. The second Constituent Assembly debate was regarding...
but there is a problem. We are talking
Yes,
about temples of public character. We are not talking about all and every temple. Right? Can you, whether your private temple in your home is open for everybody? No, it is not. So there is a difference between denominational and non-denominational temples.
My lords, but there are case laws which have also stated that the...
We are not here to discuss case laws, right? We are here to test the argument. So how do you counter my question when I say that there is a distinction between temples which are public and temples which are private, temples which are denominational and temples which are non-denominational?
Yes. So my lords, I would refer to Yes, so I would address it that
Use that wage, non-wage again. Counter. You can very well use that.
yes, my lords.
That's
Okay.
your religious faith, that because you have that religious faith that you do not eat vegetarian, you will not allow anyone to,
My
any
lords.
visitors to serve.
Yes, if we
So that-
consider
that's-
this example, firstly, when you are going into someone's home, this is a subjective example that states whether the home is vegetarian or
I
non-vegetarian.
consider
but
Sabrimala as the home of Ayyappa.
My
And he
lords,
would, and the protocol
yes.
says that he does not allow a woman of particular age group to enter his house.
Yes, my lords, again.
Otherwise, he will get aggrieved by that.
Yes.
So we have to follow that protocol.
My lords, but here when we take the case of vegetarian and non-vegetarian, the case does not bring anything that goes against the constitution. It is a concern of personal subjective matter. But when we stick to Sabrimala, it is going against the constitutional principles, the morality that is derived from the basis, that is based on the constitution. Hence, we are discussing over the same.
Counsel, when you are taking admission to any college, any school, or any school of thoughts, then you will have to follow the rules and regulations made by that institution for that particular student. So if you are entering into that temple of Ayyappa, and who is considered to be the deity, or the followers are having faith that he is a celibate god, then you will have to follow that. So if you don't believe in that, then don't enter. If you are of the opinion that due to physiological discrimination there is some kind of discrimination, go to Guwahati. There is menstruation period. It's properly allowed.
My lords, the question is not about whether the
And in continuation of that, even insofar as pregnant women, she is getting more leaves under Maternity Benefit Act, and there is no such law as Paternity Benefit Act.
My lords, exactly, we agree to this, but we need to understand that rules should also be reasonable in nature. Tomorrow, if
You made your point very clear that it should not.
yes, yes,
And you just don't want to go against the basic structure of Indian.
exactly.
If it is hitting that, violating that, forget our belief, foundation of your belief.
Exactly.
It very nice.
My lords, I will just summarize in 1 minute regarding the concept of constitutional morality. 2-3 points. First, in what context did morality come in place, and in what context did the law come in place? So previously, their morality existed from the very beginning, or the notion to decide what is right and what is wrong. But law came into force to keep a uniform right and wrong. So hence, this itself says that the purpose of law was to decide a uniform notion of right and wrong. And the second point that I would state, that it is a very basic point that when there is ambiguity or lacuna in a particular law, what we do, or legislation, what we do is we go and interpret the preamble of the particular legislation. Now, when we are interpreting the word morality, yes, my lord, just last point. When we interpret the word morality, if we go to the preamble, that is the preamble of the constitution, fraternity, dignity, equality is what we find from there. So these are itself the origin of constitutional morality. So 2 points, last my conclusion. First, sections of Hindu should be interpreted in a very broad and expansive manner, that every group should be included. And second, regarding constitutional morality, morality in 25 and 26 ought to be considered as constitutional morality. Much obliged, Your Honor.
Lordships, this is speaker number 4. I will be dealing with issue number 7. Issue number 7 talks about whether a person not belonging to a religious denomination or a religious group can question a practice of that religious denomination or religious group by filing a PI. Your Lordships, at the face of it, this question pertains to the locus standi issue about PILs. Your Lordship, it is a well-established fact that PIL matters have experience a wider locus standi than regular matters, Your Lordship. Your Lordship, there are certain exceptions, however, that are observed in PIL matters as well, because the court does not want to deal with unnecessary suits filed by meddlesome interlopers or by busybodies for unnecessary reasons. Your Lordship, so there were guidelines laid down in the Janta Dal case. If Your Lordships could come to the page 25 of the compendium. Apologies, Your Lordship. Page number 29, paragraph 64. Your Lordship, in this, it has been held that a person who is not a mere busybody or a meddlesome interloper, since the dominant object of PIL is to ensure observance of the provisions of constitution or the law which can be best achieved to advance the cause of community or the disadvantaged groups and individuals or public interest by permitting any person having no personal gain or private motivation or any oblique consideration by acting bona fide in nature, PIL in such nature shall be entertained. Your Lordship, there is no blanket ban put on religious matters pertaining to PILs. So if the general rule pertains to PILs being entered on a wider locus standi ambit, that is the general rule that needs to be exercised in religious matters as well. Now coming down to the extent of tolerance of PILs and to what extent these matters will be tolerated. Now Your Lordship, in India we observe...
Counsel, just in that context I would like to
Yes.
ask you that do you have any data which will prove that this number of percentage of women are willing to enter into that particular
Yes. Your
temple?
Lordship, yes. In 2019, Your Lordship, after 2018 judgment was passed, in 2019, 2 women did try to enter the Sabrimala temple. In this, they were accompanied with police protection. However, their entry resulted in community riots and backlash that they faced. And it was also followed by purification rituals by the priest of the temple. Your Lordship, this is the second limb of my argument where I'll be explaining this part in detail.
No,
Now,
no. Now let me ask you a very conceptual and clear question.
Yes.
Along with his question, of course, which you are going to deal, right, in your second argument. Now, we say public interest, or Upendra Bakshi call it social action.
Yes.
So where is the public interest when you poke nose in any other religion?
Yes.
You are from Punjab. What business you have to do with Kerala?
Your Lordship, the fact at point states that fundamental rights of a large interest of a large part of the community were affected.
No,
Now
but where is the large community? We are talking about a minuscule minority.
Your Lordship, in particularly when it's concerned with the Sabrimala case, in this it is also important to note that people from other religions were also allowed to enter the temple. Not just people, not just women, but men from all other religions were also allowed, not just the followers of Ayyappan community. Now, Your Lordship, even if me as a council, not being the devotee of Lord Ayyappa, I would still have the right to enter the temple, which was not guaranteed to me.
That you may have that right. That's not a problem. But can you use PIL?
See, to add further to my brother's question, see, I would like to, put some important aspects. Like this PIL jurisdiction was created in cases like Husainara Khatun, like for under trial prisoners who could not access to courts. Okay? Then in Bandhuwa Mukti Morcha for bonded laborers, in Vishakha for working women facing harassment. So every landmark PIL had identifiable victims. So here my question is, who are your identifiable victims in this case, so far as PIL is concerned?
Your Lordship, as I explained earlier, this was not a restriction on only women belonging to the Ayyappan community. This was a restriction on women from age 10 to 50 for all women belonging to any religion. Because in comparison, men of all religions were allowed to enter the temple. So as a council, if I profess the wish to practice this religion and try to enter this temple, my right was breached by the practice of this temple. So now the fundamental question here at hand comes to the point of fundamental rights. Your Lordship, in this case as well, in the Young Indian Lawyers Association case, Justice Nariman very well addressed the issue of PIL, and he addressed the point that when a substantial question of law is brought before the court, locus standi becomes a mere technicality. So in a matter which is affecting the fundamental rights of the community, which is women in this case, in the Sabrimala case for example, it is important to address the issue as a violation of the constitution rather than just focusing on the locus standi.
Mr. Consul, Ms. Consul, a practice of a religious denomination, that is the word being used by you. Now, I am sorry, you may continue with that. I will correct myself.
Your Lordship, can I continue?
Yeah, yeah, yes. I want to add to further your submissions.
Yes.
In this PIL, I want to understand because see, many of the women and many of those institutions, they came out against the judgment itself, and they say that they were not happy. I'm not saying every one of them, obviously, but substantial people came across women, and they said that they are not happy with the judgment. So my question is, you are representing whom and in what capacity, and where is the consent of all these people for any such relief?
Your Lordship, now in this particular matter of Sabrimala, even if the women of the Ayyappan community, there might be a portion of women who were not agreeing with the judgment. However, Your Lordship, this judgment opened the doors for the temple for women to enter the temples. Your Lordship, it did not put a restriction on other women from entering the temple. The restriction was existing beforehand. So the 26 that these people were practicing were restricting the entry. Now the entry that we have allowed is an enabling right. The women who do not wish to enter the temple can still stay away and not enter the temple if they wish to do so, but they are not restricted on someone else's right. This is the exact point of PILs also, Your Lordship.
Yeah, with the submissions made by the petitioners, they said that there have been affidavits filed in the court. They say that they do not want any such kind of relief. So what is your submission to that?
Your Lordship, in this case, like I already explained earlier, 2 women have already tried to enter the temple, but they were faced with a lot of community backlash. This is restricting them from taking the steps of entering the temple in the first place. Now, because of this, a sense of identity for any person comes from the sense of belonging to a particular community. If your sense of belonging is taken away because you profess a different view from the larger population of that community, your sense of identity can be taken away. The fear of being ostracized consistently exists, Your Lordship. As explained by the opposing counsels, Your Lordship, in earlier cases, they have ensured us that anonymity and live recordings of the court proceedings will ensure that this right is protected. However, Your Lordships, in the present scenario, we need to take a look at the current situation. In rape cases as well, even when the victims remain anonymous, the accused comes out on bail and shoots the victim. This is already happening in our country, Your Lordship. We cannot, there is already a fear in the minds of people to approach the honorable court in a multiple cases.
In order to justify your locus, have you done any kind of a fact-finding exercise that this particular religious faith was never prevailing since time immemorial, and this is something is completely a mythological belief? This is completely being followed by people in a very blindfolded manner, and this was never there in picture.
Yes.
And therefore, you are or your just argument is just flowing from Article 14 and Article 25 of the Constitution of India. Have you personally, to justify your locus in order to make this particular petitioner 32 maintainable, done any kind of a fact finding? Have you written any kind of a representations to the trust, to the authority, that women of this particular age group should also be allowed in the temple, because your rights are culminating out of Article 14 and also Article 25 of the Constitution of India?
Yes. Your Lordship,
or you are straight away coming to the court?
No, Your Lordship, in the Sabrimala case as well, the Indian Young Lawyers Association, the submissions were made on behalf of the petitioners, wherein they have proved on factual basis that women before 1950 were allowed in the temple. And this practice of banning women from entering the temple has been incorporated in recent times. This is not a custom that they have been following for time immemorial.
Have you put any kind of evidence to that effect on record?
Your Lordship,
or it's an admitted position?
Your Lordship, it is established in the entire 411 pages judgment by the petitioners, and it is a well-established fact in that case, Your Lordship. And it has been explained in that case, Your Lordship.
Counsel, if parties are working in collusion, in their own interests, and they are not litigating it. Whether it will pave the way to any individual who is not having any nexus to raise his grievances by way of appeal?
Your Lordship,
Are you following it?
yes, Your Lordship, in the current situation, there are certain
Parties can collide, no?
yes.
And in collusion, they may not raise those issues which are truly to be placed for
Yes.
redressal.
Your Lordship, unfortunately, in India, we are already facing, extension of 2 minutes, Your Lordship. We are already facing these issues, not just with respect to PILs, but also to other matters or other civil cases also. And Your Lordship, we completely believe, we have faith in the judiciary to exercise its judicial discretion in order to entertain such matters. Your Lordship, when it comes to the fact about entertaining or maintaining such petitions, the contention of the respondents is only that when a fundamental right is violated, the question about locus must not be the focal point of the argument. The fact at hand stands that a fundamental right has been violated and the judicial discretion has to be exercised by the court. Your Lordship, in a recent case, a PIL was filed before the Honorable Supreme Court questioning the tamsic value of onion and garlic. Here the Supreme Court quashed the petition at the face itself because it would hurt the sentiments of the Jain community. Your Lordship, the court has exercised this discretion and has been exercising this discretion. The contention of the petitioners is that they need to put a blanket ban and no outsider should be allowed. Your Lordship, as established by the learned opposing counsels, religions are present not only in popular forms but also in secluded areas of the society. In such cases, when they are not aware of the judicial remedies available to them or they don't know that their rights have been infringed upon, it is the right of us as people of the community to come and bring these matters before the Honorable Court for the court to take action upon it. Your Lordship, PIL forms acts as the eyes and ears of the Honorable Judiciary, and that's where we come into the picture. If the restriction is put as a blanket, we cannot have that because that would create a complete situation of chaos, Your Lordship.
Counsel, on one hand, you are saying that you are not belonging to that particular community or to that religion. So it means that you don't have faith in that particular God. So how do we can believe that you have not filed this petition to create a rift amongst the society?
Your Lordship, this is a very important contention.
And also that this will give liberty to many of the people belonging to different religions to create conflict between different religions by filing such kind of petitions against each other.
Your Lordship, this apprehension is... Yes, Your Lordship, this
See, tomorrow any Hindu will file a petition saying that women from our community should be considered as a qazi, which is not permissible under Islam.
Your Lordship, now... No, Your Lordship, apologies if that's what was conveyed. Yes. Your Lordship, in such a situation, the fundamental question arises about fundamental rights being breached. Your extension for a few minutes to satisfy Your Lordship. Your Lordship, fundamental rights have been breached. That is the main question at hand. If a fundamental right of not just me, but as a community of women has been breached, then the locus standi becomes a technicality in addressing the issues. And as correctly pointed out, that this would open floodgates of people creating issues. Your Lordship, in such cases, as I explained earlier, this is already happening in the present situation. But that does not mean we quash and we put restrictions on the PILs being entertained itself by outsiders, because then that would defeat the purpose of PILs. The fact at hand states that there need to be certain guidelines issued that in certain matters, when fundamental rights are an issue, only then these matters will be entertained, and the court is consistently been exercising this discretion throughout its throughout multiple judgments, Your Lordship. Frivolous suits since SP Gupta, which has been a foundational case in PILs, and in Janata Dal case, they have exercised discretion about not tolerating frivolous suits. Only bona fide suits and individual public... Only bona fide people and people with with public spirited intentions are only those suits are allowed, and this has been followed consistently, Your Lordship. However, in SP Gupta case as well and in Janata Dal, Justice Bhagwati and Justice Iyer reiterated that if we put a restriction on locus standi in PIL matters, then the purpose of PIL will completely be defeated, and we cannot have a definition of locus standi in PIL matters specifically. The pioneers of this concept itself had this view. If we put a blanket ban right now, we will be opposing to the view with which this was brought up in India, Your Lordship. That concludes my submission. Thank you.
proceed with the audience question segment, wherein the questions will be read out that are submitted by the audience for consideration of the honorable judges. The first question is, Article 25 protects the very foundation of religious freedom and the right to hold beliefs. If the judgment states that those beliefs should yield to modern logic, won't it establish a conflicting precedent wherein freedom of religion is applicable to beliefs that mirror state-sanctioned secular values?
Yeah, our constitution makes a distinction between religious beliefs, which are internal, and rituals and ceremonies, which are external. So far as religious beliefs are concerned, because it does not have impact on others, you can maintain them. But when religious beliefs reflected in rituals and ceremonies, then restrictions come into play. So as long as we maintain this distinction between belief, rituals and ceremonies, there is a balance and there is a harmony.
Thank you, sir. As argued by the Learned Counsel 3, the religious morality of the deity should be protected to have diversity and not homogeneity. So how can a deity's morality be above an individual's right, and how can the individuals who are devotees of that very deity practice their worship without restricting the morality of the deity?
By following that particular religion. If you are in agreement with that religion and you follow the practice and procedure of that particular religion, then you will have to follow. Otherwise, if you are not in agreement with the scriptures, if you are not in agreement with that particular religion, then how you can question the very logic of that religion? If you are saying that I am having faith that Ayyappa is my God, this is the home of Lord Ayyappa, then I will have to follow the entire rituals. If I don't believe that there is no such God as Ayyappa, then why the entire exercise will be redundant?
Okay, sir, thank you. The next question is, to what extent can the law regulate or determine religious rituals without infringing upon the right to freedom of religion?
See, as long as the law which has been laid down by the executive or legislature is not vague and arbitrary, and it is protecting and safeguarding the interest of the public at large, the common law principle is this, that the judicial intervention should be minimal. So as long as it is protecting Article 14, 16, Article 25, 26, and of course 25 and 26 have to be read harmoniously. We are all coming to a common, we are ad idem on this particular fact that 26 is culminating out of 25. 25 is an umbrella provision, it's a parent provision, and 26 is coming out of. But whatever restrictions is being imposed under the guise of 26, if at all those restrictions are emanating out of religious sentiments, and it is something which is safeguarding particular religious sentiments, that the courts, in my respectful submission, should not be allowed to tinker with those religious sentiments, because according to me, those religious sentiments are not vague and arbitrary.
Thank you, sir. So the next question is, if social conditioning can make subordination feel voluntary, shouldn't the constitutions guarantee the equality override such conditioned choices rather than being defeated by it?
Absolutely, according to me, such kind of a choice to choose one thing is different. And if that religious beliefs, now actually one of our participants argued that foundation of that belief, whether that beliefs are encroaching over the fundamental structure of our Indian constitution, that has to be keep in mind while when judges sit and see whether this religious belief is coming within the, or whether it is violating the constitutional basic structure, then definitely it can be reviewed, it can be viewed again in the larger interest of public, to just keep our harmony, secularism, whatever the basic structure we have in our Indian constitution, because it is almost said that society changes faster than law, and now society has changed. Well, how to see our requirements, what are our requirements right now, and where we are proceeding. So keeping in mind, that has to be done.
Thank you, sir. I would now like to hand over the mic to Kaveri, ma'am.
Hello everyone. So Dr. Garima Kautekar ma'am wants to ask one question. She is from Nisarga Shrishti Welfare Foundation and her question is based on real case which she is facing right now. Yes, please ma'am.
Thank you so much. Good afternoon, everyone. I am facing right now religion versus rights every single day. How? I will tell you later. But uske pehle, I would like to introduce myself. I'm Dr. Garima Kautekar, founder director of Nisarga Shrishti Welfare Foundation, and a TEDx speaker, as well as I received 2 honorary doctorate in social work and community development. But ये मेरा प्रोफाइल नहीं है, मेरा प्रोफाइल है how to fight against noise pollution, और इसके लिए मैं काम कर रही हूँ 12 से 15 सालों से भी ज़्यादा इनफैक्ट, और हमारा काम फ्रांस 24 टेलीविज़न ने कवर किया है, एज वेल एज लास्ट वीक बोल सकती हूँ मैं, बीबीसी ऑडियो ने हमारे ऊपर डॉक्यूमेंट्री बना के पब्लिश किया है। बीबीसी ऑडियो की बात करती हूँ तो मैंने ऑनलाइन 13.3 मिलियन लोगों को अवेयरनेस क्रिएट किया है अगेंस्ट नॉइज़ पॉल्यूशन। लेकिन मुझे ये बताते हुए बहुत दुख हो रहा है कि हड़पसर में ही 13 दिन पहले रंजना जाधव नाम की एक लेडी ने अपनी जान गंवा दी नॉइज़ पॉल्यूशन के कारण। इतना ज़्यादा नॉइज़ पॉल्यूशन था कि वो सहन ही नहीं कर पाए, हार्ट अटैक आ गया। अब मेरा ये, जैसे मैंने आपको बताया कि मैं रिलीजन वर्सेस राइट्स को एवरी सिंगल डे टैकल करती हूँ। मेरे पास 100 से भी ज़्यादा ईमेल्स आते हैं स्टूडेंट्स के, जब वो एग्ज़ाम के दौरान पढ़ नहीं पाते, जस्ट बिकॉज उनके घर के सामने टेम्पल है, वो इतना ज़्यादा लाउड स्पीकर बजाते हैं कि जिसकी वो लिमिट भी तय नहीं करते। अभी मैंने यहाँ बैठ के चेक किया अपने डीबी मीटर से, तो हम लोग अभी राइट नाउ 85 डीबी पे बैठे हैं। अगर कॉन्स्टिट्यूशन की बात करें तो यस, बहुत सारे लॉस हैं इन्वायरमेंट प्रोटेक्शन लॉ एक्ट के तहत 75 डीबी से ऊपर नहीं होना चाहिए, ये तो लॉ कहता है। लेकिन क्या कहें, जब अनजाने में लैक ऑफ अवेयरनेस के कारण 110 डीबी पे डीजे बजता है और उसके कारण एक लेडी की जान चली जाती है। मैं उसके मतलब जान जाना तो अब ऐसे कॉमन हो गया है कि यहाँ पे लैक ऑफ अवेयरनेस इतनी ज़्यादा है इंडिया में कि हम कैसे करें, कैसे रूल्स एंड रेगुलेशन एंड प्रोटोकॉल को कैसे मैं वो लेकर आऊँ, कैसे वो स्टॉप करूँ इस अवेयरनेस जो नहीं है, कैसे मैं अवेयरनेस क्रिएट करूँ। तो ये मेरा क्वेश्चन है कि लॉ और रूल्स को हम कैसे चैलेंज कर सकते हैं या चेंज कर सकते हैं, या कुछ अमेंडमेंट जो भी चेंज कर के ला सकते हैं, ताकि लोगों को एटलीस्ट थोड़ी सी इस बारे में समझदारी रहे और लोग बाग केयरफुल रहे, ताकि किसी की जान ना जाए।
There are ample provisions to curtail such situations which are coming against us in the form of noise pollution, in the form of any trouble which is seriously cognizable. Then there is part 12 of Code of Criminal Procedure Old, under which begins with section 154 of CRPC, in which you can register offense as well. Now, so long as awareness is concerned, now the parties which are celebrating are so dominating that an individual may not be able to agitate. If fearlessly one goes only, now situation is such that many people may have cry that police don't take cognizance because there is something underhand going, and there may be some politician, some criminal, because of which we fear that we may not lodge report. Actually, this is not now the situation any longer existing. Reason being, for every police station there are mails, emails, and by mail if you lodge a complaint, they have got to take cognizance of it. There cannot be any person or authority who cannot take cognizance. If you go and approach before police station officer, he may turn down you. But if you send complaint through mail of that police station, cognizance is required to be done, is to be taken, because that is required to be redressed. And that those copies means that daily crime is informed to superintendent of police of every district and commissioner single. The only lack which we are feeling in such cases is we are not taking initiatives. भानगड कोणी करावी असं वाटतं, and we confine to that, and we may not have courage to do that. If we have courage, we can get redressal, definitely. I am confident about it.
No, in addition to what my learned friend just now said, there is also, the rules which were made for noise pollution rules 2000, in which, as you mentioned, that there are certain decibels which are mentioned. So there are 3-4 criteria of areas where these decibels have been, set forth, like commercial area, industrial area, residential area, or maybe silent zone. So there are different decibels allowed. If it is above that, then there is also punishment prescribed in the same rule, which can be even 5 years imprisonment, along with fine of 1 lakh, for the first instance. So in addition to the provisions, what my learned friend just now stated, these are the specific provisions so made, and you can file proper complaint before the concerned police station. Otherwise, you can also approach the court. If the police fails to register your complaint, you can file under section 175(3) of BNSS. Right?
एब्सोल्युटली सर. एंड जितने आपने पॉइंट्स बताए हैं वो सबके सब मौजूद हैं, बट स्टिल मेरे पास जो कंप्लेन आती है वो ये आती है कि हमेशा जैसे फॉर एग्जांपल एक टेंपल की बात करूँगी मैं, वहाँ जो स्टूडेंट रहता है सामने वो बहुत परेशान है, वो 12th के एग्ज़ाम नहीं दे पा रहा है. जो मेरे पास में ईमेल आए, मेरे राइट्स के अंदर इतना ही है कि मैं उन्हें रिक्वेस्ट कर सकती हूँ टेंपल के अथॉरिटीज़ को, या फिर वहाँ पे जाके कंप्लेन कर सकती हूँ, लेकिन इसके बियॉन्ड मैं कुछ नहीं कर पाती. और एज ए NGO फाउंडर डायरेक्टर मैं पूरे 12 सालों से प्रयत्न कर रही हूँ कि अपने इंडिया में से नॉइज़ पॉल्यूशन कम हो. पूरे पुणे में हमारा NGO नंबर 1 पे है नॉइज़ पॉल्यूशन को कम करने के लिए, पूरे इंडिया में टॉप 4 पे है, और वर्ल्ड पे BBC पे आने के बाद में वर्ल्ड के टॉप 10 पे आ गया है. बट स्टिल मैं अभी भी लाचार हूँ उन्हें समझाने के लिए लोगों को कि ये नहीं. और जितना आपने बताया कि पेनल्टी है, बहुत कम है सर, बहुत कम है, क्योंकि किसी की ज़िंदगी चले जाना और वो 2000 से 1 लाख की पेनल्टी ले लेना, हम इक्वल नहीं बोल सकते. यहाँ पे मैं प्रयत्न कर रही हूँ कि स्कूल्स और कॉलेजेस को इनिशियल लेवल पे ही पूरा अवेयरनेस क्रिएट कराऊँ. वो तो मेरी एक टीम कर रही है. दूसरी टीम रिसर्च के काम पे डिवाइस भी, मेरे पास खुद पेटेंटेड डिवाइस है दैट विल रिड्यूस नॉइस पॉल्यूशन इन इंडिया. वेरी सून आई एम गोइंग टू लॉन्च इट. और उसके बेसिस पे मैं कहना चाहूँगी कि आपसे मुझे गाइडेंस चाहिए, आप लोगों से मुझे सपोर्ट चाहिए, सारे स्टूडेंट्स का मुझे साथ चाहिए एज ए वॉलंटियर लेवल, एज ए मेंबर, क्योंकि मैं अकेले नहीं ला सकती हूँ. कोई भी बदलाव मैं अकेले नहीं ला पाऊँगी, लेकिन आप लोगों की मदद से ज़रूर ला पाऊँगी. तो थैंक यू वेरी मच, आप लोगों ने मुझे यहाँ पे मौका दिया अपनी बात करने का, और आप सभी के गाइडेंस ज़रूर मैं चाहूँगी इस मुद्दे पे. थैंक यू सर.
Thank you, ma'am. So I will proceed for vote of thanks now. So good afternoon, everyone. It's my privilege to propose a vote of thanks today. I, Assistant Professor Kaveri Aditya Dev, on behalf of Deccan Education Societies, Shri Navalmal Firodia Law College Pune, Moot Society, would like to express my heartfelt gratitude to our esteemed 9 judges panel, Dr. Sanjay Jain sir, Shri Sunil Ved Pathak sir, Ms. Vinaya Raichur ma'am, Advocate Ashutosh Srivastava sir, Advocate Om Prakash Kashit sir, Advocate Bhushan Tapasvi sir, Advocate Abhijit Desai sir, Dr. Vikramaditya Rathore sir, Advocate Rajesh Katore sir, whose insightful observation and guidance added immense value to today's mock hearing. Your guidance has not only enriched our understanding, but also encouraged us to think critically about maintaining the balance between religion and right. I also extend my thanks to our media partner, Law Octopus and Law Bhumi, and our knowledge partner, Guru Ki Solutions LLP, for their support. Further, I would like to extend my gratitude towards Sri Pramod Rawat sir, Chairman of GBN Council, DES Pune, Advocate Ashok Palande sir, Vice Chairman of DES and Chairman of College Development Committee of DES SNFLC Pune, for their continuous support. I also extend my gratitude towards Principal Dr. Sunita Adhav ma'am for her continuous support and guidance. I would like to also thank Dr. Janavi Godke ma'am for her support. Further, I extend my thanks towards teaching, non-teaching, office and library staff for their unconditional support. I would like to thank advocates, academicians, NGO members, media and press members, students and other participants for their patience, attentiveness and engagement in today's mock hearing. Your presence made this event more meaningful and impactful. Lastly, I would like to thank all the speakers of mock hearing, all the department heads, all the volunteers and members of Moot Court Society for their dedication and hard work to make this event possible. Lastly, I extend my thanks to everyone who contributed behind the scenes. Thank you so much. I request everyone to kindly stand up for Vande Mataram.
Vande Mataram, Vande Mataram, Sujalam Sufalam, Malayaj Sheetalam, Shasya Shamalam Mataram, Vande Mataram, Shubhra Jyotsnam Pulakitayamini, Pullakusumita Drumadala Shobhini, Suhasini Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Koti Koti Kantha Kala Kala Ninada Karale, Koti Koti Bhujai Dhita Kara Karavale, Abala Kenumaya Bole, Bahubaladharini Namami Tarini, Vipudalavarini Mataram, Vande Mataram. Tumi Vidya, Tumi Dharma, Tumi Riddhi, Tumi Marma, Tvam hi pranaha sharire, Bahute Tumi ma Shakti, Hridaye Tumi ma Bhakti, Tomaroi Pratima Gadi Mandire Mandire, Vande Mataram, Tvam hi Durga Dasha Praharana Dharini, Kamala Kamala Dala Viharini, Vani Vidya Daini, Namami Tvam, Namami Kamala Mamala, Atula, Sujalam, Sufalam Mataram, Vande Mataram, Shamalam Saralam Susmitam Bhushitam, Dharanim Dharanim Mataram, Vande Mataram, Vande Mataram.
भारत माता की जय।
I request all the faculties, student heads, speakers to kindly come forward for the group picture with the dignitaries.